A metal, only one point. With regard to minor metal, there is one point is involved.
Yes, it is appearing under the heading motion. It is appearing in the list. I will have to proceed serially because motions have to proceed serially.
I'm coming with regard to metal model because of certain company circumstances. I cannot say it.
Let me see here. Motions, the other.
Kindly give some from.
All right, I will consider, I will fix that time. Yes.
May I have your lordship's time?
Today may not be possible, let me see, because there are some orders. I will consider that. Let me see how far.
May I have your lordship's kindly to mention this matter in regard to a cooperative society matter. This government holds a majority share of the cooperative society.
What do you want?
That recruitment is going on in violation of the 2011 rules of the society, man. That is why and the
File the writ petition.
It is ready, my lord. It is on the first the recruitment examination is fixed. That is the
File it, keep the date, it will appear. Yes.
If it can appear tomorrow, man, subject to your lordship.
If I may mention a matter for extension of entry mode expiring tomorrow, lordship.
Please hand over the slip indicating when it is expiring.
Yes, sir. We indicate an application.
If my lord's court officer kindly gives me
You appear tomorrow, but you have to serve upon the application for
inclusion, lordship.
application for inclusion.
It is not happening. Okay, filed an application for appropriate order. Okay, what has happened?
Application
Yes. Filed one new motion for inclusion and one application for restoration.
Motion for inclusion. This matter was fixed under prediction for orders on April 2024. Matter for urgent hearing.
Hearing, please wait. Yes, call the list.
Eviction order is issued against the.
Yes, call the list.
Item number one.
Item number one, I want to thoroughly execute I pray.
Put the appropriate forum.
It is not
Tribunal. The
Item number two.
yes. Yes, Mr. Vadi.
The basic involvement Federal Acquisition Act affects the transfer which was made in our favor. That's the basic issue. Now, kindly, therefore, since this is the crux of the issue, I take your lordship to the acts. Right.
But Mr. Bhattacharya, are you challenging the order of vesting?
I am not changing on the list.
Prayer B, please come in front.
Prayer will not maybe will not allowed to be amended. Court may class will not the
No,
prayers.
you want to withdraw this prayer, not press this prayer.
I will not place that prayer at this stage. No.
No, then you have to not press this prayer. I will record that.
We should proceed with that, but our basis is to.
No, then I will record your submission that you are not pressing your challenge insofar as the vesting orders are concerned.
Yes, we have filed an
Those-
amendment application. We have filed an amendment.
Vesting order, not of course, we have made a point of your lordship. Lordship, can we set the prayers?
Yes.
The first prayer, which might be the troubling my lord, it might.
First prayer is not troubling. After that, it's what is troubling.
If the first prayer is not troubling, then the other prayers that becomes consequential.
But consequential vesting orders, Mr. Bhattacharya, that's difficult. Vesting orders, because under the statute, there is a specific provision you have to challenge.
No, I
those.
follow. There is a question of forum.
Well, that is the.
Therefore, that if your lordship will not finds not my first challenge that this the acquisition act did not really will not affect me, then the question of vesting challenging would not arise. If your lordship is against me, then I have to challenge them before the appropriate forum. That's a different forum. But at this stage, I would invite my lord's attention to consider whether the management taking over and subsequently the acquisition of the particular company would affect my right. If your lordship decides that, no, that will be sufficient for me at this stage. I will proceed to that extent.
So you have filed an application for amendment.
That my junior has filed an application. But lordship may not be troubled with that application at this stage now.
I can allow this application
Not
at this stage.
but it's on record. If your lordship is satisfied, then if your lordship will not, or lordship will be kind enough to say that this prayer may not be prayed.
Yes,
That kind of
you are not pressing your prayers such and such.
keeping liberty to challenge whenever the situation
Yes,
arises.
that is. If you do not press, you will be at liberty. But if it is there considered, you may have difficulty.
No, I follow. Not this problem of forum. I follow.
That is only because of that. Because when a tribunal has been constituted, you know those line of decisions which say.
That is the first forum. As per the Chandra Kumar. No
Yes,
problem.
court of first instance. That is the language
That
used.
is there.
And that is the scheme. So first you have to go there. Thereafter,
Fast to check. So that if that comes within the scheduled set.
yes. So here it's that vesting order is under the scheduled statute.
But I am not really troubling my lord intent now. I am going to first cross the hurdle. Let me enter into the room. Then
All right. So then I am recording that you are not pressing the other prayers.
lordship may record
Yes. Which are the prayers you are not pressing?
the prayer B.
Even just the last prayer of prayer A. So we have also deleted that.
The never stood vested.
We have deleted.
That's the challenging the vesting. But in fact, that would not be even a challenging the vesting.
But kindly take the page 44 of my amendment application.
Page 44. Yes. Yes. So prayer.
Deleted by that reading.
All right.
When we deleted that.
Then Mr. Bhattacharya, have you seen this amendment application? I am allowing this amendment application. There are other changes in the amendments.
Prayers are concerned, but amendments should not
I in body wherever the
Yes, vesting order. So I am allowing this amendment. Yes, what do you have to say with regard to if I allow this amendment application?
No.
So I am allowing this amendment application. So the interim order can be extended.
But the third lordship, can you hear out the matter, madam? These 2-3 days,
Then
nothing will happen.
matters may take time.
But
Because that was your objection. I was also prima facie of the view that this with those payers it cannot be maintained. With regard to that, then you do not have any objection with regard to the maintainability. It's now on merit. Merits, I will hear since the interim order was continuing because I was not inclined to extend because the maintainability was clearing at the pace according to me. That was the prima facie and you have
for a limited period, madam.
I think that will because
Any day, madam.
then I'm fixing it after that because I think this will take time.
Some constituents.
এইবারে না এবার রিট পিটিশনটাতে একটা অর্ডার করে দিন
is subsisting as on date, but it is due to expire on 31st of January. It was subsequently also extended from time to time. Now,
what is this matter for
yes, your lordship will see that this is a writ in the nature of prohibition, prohibiting the respondent state authority from acquiring the property without following due process of law. Because so far as the subject land is concerned, it is Banglahat market. It's a huge area.
Bada Manglahat?
Yes,
Who is the petitioner?
I'm the petitioner, Your Lordship.
No, that
Your Lordship had appeared.
Mr. Gupta, can I take up this matter?
One prayer only subject to, if your lordship may once look to the order, that is the parent order is 6.
Mr.
No,
Gupta, if
no,
I
I will not insist for that, because I know.
parent,
Order is 16th June 2025. Kindly have a look to paragraph 7. Paragraph,
oh, this order.
kindly have a look to paragraph 7. Thereafter, your lordship will file on 29th August 25. May I hand over this order? This is on record also. May I, Willards, considering that the matter is a large property of 168 kata, the interim order will expire on 31st.
That is.
And all, what is the difficulty that all who are not outside are just entering in the property, the interim order which is due to expire on 31st. Only I would submit with great respect.
That
You
is.
I will sign it.
extent
I will sign it just now. That much I can do.
But Your Lordship, kind enough to have it extended.
But for any
If
period,
I am not
because
inclined to
we will
take
not
up
be
this
able,
matter, I cannot extend, madam.
we will
Otherwise,
not
I
be
could have
able,
taken up.
we will not be able to get it extended within 2-3 days.
Why?
It will be difficult.
এটা একটু করে দিয়ে দিন, আমি একটু দেখবো।
No, no,
Since I'm not inclined to take up this matter on ready to mention. Before the, to take place before the
Possibly, but there is other bench available. So it is-
other things available.
Because there were direction for affidavit, and since it is a
Hearing.
hearing matter,
It is a
for
hearing.
hearing bench is
It is a
available.
hearing matter. There was a
Whereas the
direction.
matter is-
There is direction for.
No, then I am not, I think that will be
Assignment
easier.
would be necessary in this case, because
Just,
in view of
parties will be at
direction.
liberty to take appropriate steps
For that,
upon notice to,
yes, all are appearing. Yes,
upon notice to each other.
yes, yes.
তাহলে ওই এটা
So we can try,
এক্ষুনি করে দিন, আমি সই করি।
if the hearing bench can take up it. we
Yes.
can try.
Just call the next matter.
Same-
Next is same order. Next,
In earlier one, I have added respondent, in next I am finished.
Tomorrow another matter will come.
No, the same fate will happen.
tomorrow another, for extension.
This
That also will be governed by same order.
analogous man.
There were actually 4 matters.
But that is also expiring on 31st. Who is for the petitioner?
One order passed in one with in your benefit. Therefore, I think there will be no difficulty. Let them come tomorrow so that same order can be passed. Thank you, Baba. Because one order
You
will.
can mention that if it appears, I can treat it the supplementary list, I can also pass that on. And provided all of you agree to that.
He made one matter is
Gopidas Nimani number.
number two.
The parties are all here, but I am giving the.
Where is your other side is not here.
No,
Still
the
there.
state is party.
All right, let it appear tomorrow. Call the next matter.
Any one order will help.
Call the next matter.
Order number 5, sir.
Yes. Yes.
Earlier order was passed on my lord.
Lordship, West Bengal Highways Eviction of Unpaid Occupants Act for the eviction of
I was 25, but Lord was pleased to fix the matter, my lord, till last of my lord January 2025. The interim order is still existing, my lord, and your lordship was further pleased to direct the respondent, my lord.
yes, affidavit filed.
No, my lord, yesterday I have received the my lord opposition by the my lord private respondent.
Yes, because they
My lord, I am not filing the opposition.
up till now.
You are not.
My lord, the inspector has not come for the patent board.
Yes. When you will file affidavit to the opposition?
But your lordship can, my lord, I
2 weeks.
Last week, Mr. Mr. Devi was not inclined to file any opposition. Last occasion.
go at church.
What do you say, Mr. De?
My lord, previously,
Do you want to file opposition or you don't want to file opposition?
বলেছি my lord, I don't know what.
Oh, when did he say it's not recorded?
No, not. But
What is the issue here?
issue is my father was obtained.
What are you challenging here?
Challenging the order passed, my lord, under an proceeding 10-3 passed by the my lord SDO. Kindly comment page 91.
On what? Yes. On what ground?
My lord, my father has obtained a plot of land under Homestead Land Act. Now, my lord, the SDO concerned SDO without verifying anything, my lord, or direct the DLL, my lord, to my lord, change the my lord record of rights.
Yes, yes, yes. I think Mr. De, please file the affidavit. That would be better. On the prayer of Mr. De, 6, yes.
And it's a state matter. Section 8, the application is right matter that was not referred to the authority matter. Some time matter within that period after.
Is it within time?
Yes, according to me within time, but subject to the satisfaction with regard to limitation. Subject to the verification.
Acquisition under which act?
Act 1. The defect is there, page 16, kindly see under Act 1, but instead of 18, it's strongly captioned as 8. Yes.
8. So land reforms are preemption. This happens with the civil lawyer. They are more conversant with section 8 of the land reforms. The petitioner
The page number will be 14 to 70. Number 7.
Same mistake, section 8. Without verification, without affidavit. Now this is to be rejected, Mr. Mukherjee. I think one application has been rejected.
1999 is was submitted and your lordship was the description of what is the format and all that.
Land acquisition character 24 Parganas not.
Everything is same, not only page number will be.
ওই অ্যাপ্লিকেশনটা পেজ নাম্বার হচ্ছে 14 to 17 আরই সব মানে ওটা ভুলও আছে সেকশন 8 ও আছে This is not computerized, not cut copy paste. It's a type. Same mistake. Yes.
Number 8. 8 also will have the page number same 14 to 70.
Incomplete application, caption wrong. Page
14 to 70.
based on cost. Based on cost. 14 to 17. Same. Yes, next.
Number 9.
Same.
9 to
Same.
yes, 14 to 70.
14 to 17.
May I just check?
Same mistake, Mr. Mukherjee.
Here,
No.
may I check?
The first one, section 18. এখানে ওই
Here not
wrongly captioned as লিখবেন না
28.
ঠিক আছে
But here not 14 to 28.
14 to 28. Why? Many petitioners.
Yes.
Separate applications.
Separate application.
Deficit code is Mr. Mukherjee. Please put in the deficit code. ঠিক আছে
Because in
এখানে না wrongly captioned ওই কথাটা শুধু লিখবেন না সেপারেট অ্যাপ্লিকেশনস লিখে দেবেন বলে দিতে হবে নাকি সেপারেট অ্যাপ্লিকেশনস করে দেবেন একদম উপরে একদম লিখুন several persons
My application in 19.
you're for the petitioner
Yes.
yes
In 1968, this particular property was vested. Now they want to take over possession.
which act which act
Estate Acquisition Act.
state
Acquisition Act 1968, 2024 is
the
representation.
is under the vesting order
It's vesting, Malad, not estate acquisition.
no it
Estate
appears
acquisition.
it's under estate acquisition act
Malad, this is Malad, kindly comes to page 30. 29. 30. Can you read one of the Estate Acquisition Act?
which page Mr. Yes, schedule B
Schedule B.
it's estate acquisition act
Page 30.
yes schedule of vested land
Vested land. Okay,
You have to challenge the order of vesting, not here, Mr.
Not
There's
here.
an appeal, thereafter tribunal.
Thereafter
specify-
tribunal, there are civil suit. আরে দাঁড়াও না, আমি জানি তো। তুমি জানো আমি কি একদম পাঠশালা Otherwise, now we had said that we are going to set up another land. We are staying there for 80 years. I'll give you another land. You just change it. You take this as residence and die.
There's a provision, if you want to change your option, there's a procedure that cannot be done now.
Very true, Malad. After so many years,
After so many years, nobody knows that those lands you may have transferred.
No, they are not.
Somebody
They
else-
are trying to make a fire brigade of fire station.
But,
So let that be considered, Malad. Let my reputation be considered. But that is not in.
If you say representation to be considered, that you have to go before the tribunal.
Tribunal. Only for consideration of the restriction, he has to go to the tribunal, not in the high court.
Malad, that order can be passed by your lordship. But
No.
consideration of representation.
After L. Chandra Kumar, there is no.
Malad, there are
That may
decisions.
may sound to be very innocuous, but the question is, it's an inaction
Yes.
of an authority. So in taking some action, you have paid for certain things in action. That's also covered under section 6 of the Regional Land Reforms and Tenancy Tribunal Act. And you know those line of constitution bench judgments and other things which say
Particularly the.
that will be that tribunal is under 323 capital.
Absolutely.
So that has been,
अरे ये तो बहुत जानी बात
has been constituted under
97.
323 and it has been held at the tribunal. So now the scheme is that initially what happened prior to the tribunal was the single bench was the court of the first instance appeal. It was an intra-court appeal to the division bench from the single bench, not 226. Now the scheme is that initial court of first instance is the tribunal, from there 226 before the division bench. So the scheme has changed. When the scheme has changed,
I have seen some judgments of 2002. I can place that. The High Court can pass that order.
sir,
I will not try to.
I have heard one matter. I have reserved for judgment. I will be delivering, I think, in a few days. This was the
On this particular issue. Then kindly.
there the order was even better. The order was without jurisdiction, or the so it also falls under 226. Can be even if
Yes.
we go by those line of decisions that availability of an alternative remedy is not an express bar in entertaining 226. But when the single bench power has been taken away, the question is whether and only 226 with the division bench. That's the statute.
But Malad, at the same time, the statute cannot override the constitutional mandate.
That's for that. You know very well, L. Chandra Kumar, only in the Administrative Tribunals Act, the entire power of 226 was taken away.
Yes.
So,
yes.
There, the Honorable Supreme Court said, no, that cannot be taken away. So only the High Court's division bench power of 226 was restored.
Yes.
Was
That-
preserved.
Yes.
Was preserved. The act was read down to that extent without declaring it to the ultra-virus. It says those observations. Now, after that decision was delivered, after 6 or 7 months, this Tribunal Act of West Bengal Land Reforms and Tenancy Tribunal Act has come.
But Malad, that
Curing that defect. So that principle has been borrowed in section 8, excluding the jurisdiction of other courts, preserving the jurisdiction of the division bench under 226.
Malad, in 2001, Malad, I know what is forbidden and I know actually what is correct. But I have thought about it. But if the High Court jurisdiction of passing a direction is taken away by an act, a constitutional mandate I have. Equally before law, you have already allowed others to hear it, you are not hearing mine. That is not covered by the act.
Actually, okay. If you go by the object of this tribunal, is to take away the workload or to reduce the
And
workload
they
of
really done it.
Mr. Vasu, let us not go into that controversy, but that was the object for which to lessen the burden of the
Malad, in
High Court is that-
1997, I just passing. 1997, I was put and Mr. Jetty was there. So after I did the mapping, and I was talking to the lady, he said the first thing if I'm going to become a law is just remove all 25 minutes. These are waste things. That really.
That's
But he did not do it. He did not do it. He said in 1997 in the corridors of Supreme Court, but he didn't do it. But now, as it stands, the tribunals are basically from the French law because it's in the of tribunal.
no, but,
It's practically a wastage.
but when that
1
is
year,
there,
no judge, then one.
when that is there, a forum has been created. Otherwise, no use. There will be a Mr. Basu forum shopping will
Well,
be.
then only then I will only say this much, but absolutely, but I'm not trying to take any more time. If I file an application,
That
I'll
I'm giving you leave to
15 days.
withdraw this to file an application.
Within 15 days, they will consider. And that
Right.
might be given. Otherwise, they're constructive. They're constructive on my part. Not that much, nothing. Only that.
Uh, the petitioner has prayed for a direction. Mr. Basu, it becomes difficult to pass. If those directions are passed, because I was in the 227 days, I found that time will come. It's not very far away. When unless an order is direction is passed, those matters cannot be taken. That time, and that's not very far away. I am telling you.
What I have found in the lower judiciary, I've been continuously.
Don't use that expression.
Oh, no, it's not what the trial courts. What I found, I'm sorry. That after 3 o'clock, they're generally.
Not that really.
In Alipur, I have found it, so many times in city court, it's always there. I've not seen after 2 p.m. through the matters now. So it's not that they're very overburdened. It's not that they're very overburdened. They're becoming lazy. Anyway, but that's a fleeting thought. Lazy.
Thank you. Yes, college matter.
Item number 11.
Yes.
I am resist the credibility of this petition. When you are the filing of because my relevant client specifically wants
Correction of record of right. The petitioner Faced with the situation, the learned advocate appealed for the petitioner.
So very huge prayer for your lordship. My remedy is the before the trial court. I know this point will be raised.
Trial court.
Yes, for specific purpose. What I have submitted a representation before the Digha Development Authority.
Before the
Digha Shankar Development Authority.
For
What
what?
happened?
For what?
I am in possession of a particular plot of land. The original lease deed was executed between the government with the person who has physically transferred me the property. He has accepted money and executed an agreement. It's a non-registered agreement. Subsequently, her legal heirs also accepted money. So my remedy is before the suit for specific performance. In the meantime, I have obtained sanction plan from Digha Shankarpur Development Authority. I am paying municipal taxes. I have obtained electricity connection in the subject premises. I am in possession. Behind my map, the private respondent, they have mutated their name. I have submitted a representation to the Digha Shankarpur Development Authority. Let a hearing be given to us and thereafter take steps for the purpose of mutation. That is my innocuous prayer.
He has
Consider this pattern order saying that
he has in fact challenged the reasoned order at page 45.
reasoned order.
Yes, they have filed. They have already recorded their name. I said that hearing was given. Mutation has been done behind my back without giving any intimation to me. The order has been communicated by the Shankarpur Development Authority to me. Thereafter, I submitted a
They were
representation.
not heard, Mr. Bihari.
To be heard, subject to lordship pleasure, the legal locus has to be established. I will kindly see the locus of the petition. May I just take your lordship to one or two paragraphs? I will kindly take the
Of the
trouble
petition.
of the repetition. I will kindly take the trouble to take paragraph 3.
Yes.
Your petitioner said as the lessee therein, namely Kamalananda, could not fulfill the terms and conditions contained in the lease deed, the state Kamalananda, since this is executed on agreement with the petitioner, thereby permitting the petitioner to raise construction on the property obtaining valid section plan from the local bodies. So this is the number one, the local body is the panchayat, not the Digha Shankar Development. So this is the the crux wherefrom his right accrues. That the lessee has executed one agreement enabling him to make construction.
There are provision in the lease
to make construction, but it's subject to logic correction. This does not give him a locus to file it. He does not have a locus. He is right, there is no right accrued in it. Number one. Number two, what has not been stated in the writ petition is two separate applications by him and by the person who is lessee who are filed before the land reform tribunal. But I don't have the documents with me right now. His application was dismissed. I have a copy of the order of dismissal.
So I
that is online. I'm doing that.
That application was for correction of record of right.
I do not have the copy of the application. But
So the order from the order.
What has been supplied yesterday online to me is the information slip saying that the application filed by him has been dismissed. Another application was filed with the lessee also. First of all, lordship has to ascertain what is the legal right being infringed. Simply either asking for a representation will
Don't have any right.
see, let that be said by the authority because
I have legal order.
You have your remedies, please go there.
I know that my remedies.
Unnecessarily you are delaying. Please approach the appropriate please.
My representation is pending before the authority.
All representations.
This is the
order. Not what
this is the order which I have received. May I just kindly see what I'm sorry. And this is the right hand corner. This is the OA filed by my writ petitioner. And this is one of the information slips. OA dismissed. I do not know what the subject matter was.
Appeal B and the same is dismissed on contest.
So, appeal normally means that he had preferred some application before the correcting authorities.
The privileges senior division.
I'm sorry, the OA was there by this.
Not before the tribunal.
No, I'm sorry. So something has been.
Subhendu Manna, who is Subhendu Manna?
Petitioner before your lordship.
You have filed an OA, appeal. OA has been dismissed.
Lordship, I was coming to that. I am for the private respondency legal heirs of the lessee.
Yes.
Lordship, the document on basis of which my learned friend's client's basis has been made in the repetition. Lordship, that has been cancelled by the learned civil.
That listing,
Yes. Not
that
listing,
agreement.
That agreement has been cancelled. Lordship,
Lordship, apart from the agreement, the
If
private
then-
respondent, they also accepted money from me.
that's a different thing.
For that, I'll
That's out your rights before the civil court, but here you do not have any right. If the civil court has, where is the order?
order to order daily. Lordship will kindly take up page 2 of the judgment.
This is the appeal court judgment.
Appeal court judgment affirming the judgment passed by the trial court.
What was the prayer in the suit?
Suit was, Lordship, it was my suit for eviction and recovery of possession. Lordship will find that at page 2. At page 2, suit for
Yes, sir,
eviction.
this is to be dismissed with exemplary cause.
That was what I.
Suppression,
Lordship, that was not known to me. If that is so,
suppression.
there is a gross suppression, I admit, Lordship, but it was not.
I was under the impression you have to go to the civil court. You have approached the civil court up to the appellate stage.
And
It may be
execution is
for
pending.
in respect of the other, but the
No,
present legal heirs, they also have accepted money from me for transferring.
that's the difference.
that other unit.
But this is, you have not disclosed that. You have not disclosed that.
And Lordship, the conclusion is Lordship will kindly take up.
Are you an advocate?
No, my client was the predecessor of my client.
Oh. Oh, you are the plaintiff. You have challenged that.
Yes, plaintiff my suit decreed upon by the
What was the relief claim in the suit?
Lordship kindly takes up the first line of page 2. This is a suit for eviction and recovery of possession.
Against him.
Lordship will find the names of the parties on the first.
The property is the same.
Yes, it is the same. And Lordship, page 29 and 30, Lordship, is the order in motion. The appeal was dismissed against the respondent with cost of rupees 5,000.
Yes. Now some more zeros on the right hand side has to be added now. 2, 3 zeros, not many.
Leave it to your lordship. I have nothing to say, it's a gross suppression, which ought to have disclosed. Lordship, kindly permit me to withdraw.
The petitioner Yes.
Land has been acquired for project of Kharagpur Bardhaman Noregram Economic Corridor. And LAS has been started in the year 2023. Notice has been served, but no compensation has yet been made by the authority concerned. Page 22 is the notice which has been served. Plot number 267, that is award serial number 6.
Award serial number, award has been declared.
Plot
This
number
is-
267.
Oh. So you are not agreed by this compensation amount.
Not
Then you have to challenge that.
But these amount also not paid. These amount also not paid.
He has not received the lot, he has stated in paragraph 7.
Yes. Yes. No compensation has been received. Why this amount has not been released?
But if she is not willing to accept, my lord, we have received, issued the notice, my lord, P3, page 22.
Did you appear?
Yes, I appeared.
When did you appear? Where have we said that when did you appear before the authorities?
That is
Where is your specific statement that you appeared on such and such date? Show me that averment.
page 7,
Page 7, paragraph.
page 6, paragraph 7.
Page 6, paragraph 7.
While that the petitioner made with the competent authority of land acquisition.
When? Please give the specific date on oath. I will call upon them to controvert that on oath. Please, you have to state the particular date on which you visited that office. Such vague statements will not do.
Now, he has, this Miller, it's a bigger amount, he is not satisfied with the amount as determined by the, assessed by the Kala. He made representation just before 1 month. It has been issued in the 2024. And representation made me out on 17th
25.
December 2025, just before 1 month. If he is agreed with this order, please define my lord arbitration.
When did you visit?
That was
When will you attend? This amount will be paid. When?
within 7 days I will get it. Within 7 days.
I am adjourning this. After 7 days, please approach the authorities. Then, okay. The grievance of the primary grievance of the petitioner is that the
মানে ডেভিডের সাইড স্টেপ
Second one.
Then.
Yes, next.
Item number 14.
Well, I have got the petition for early hearing of the appeal, my lord, pending the
What appeal? 10-4.
My lord,
You are the state
for state, my lord.
and it's your appeal.
No, my lord.
Other side's appeal. Have you served upon the private respondents?
No, no, my lord.
Why have you not served? Why have you not served?
I have 45 seconds for that.
Why have you not served, sir? The just to speak. Just to speak. Yes.
This is in the interest of the petitioner company. I think granted these are vast tracts of land, but by the erstwhile Raja. That lease was in 1920. It is annexed to the petition. So
Yes.
subsequently, after the Estate Acquisition Act, where there was a dispute with the state government, which was settled on the intervention of the settlement is at rate 46. Kindly consider.
46. Now what do you want? What is your response plan?
Establishing under the levy under the Maharaja. Well, I'm challenging a notice, which is at the last annexure, page 93,
90
by the state government, the forest department. I think it is without jurisdiction because under the settlement reach, the stamp of approval of this board. This land, a portion of which has been leased to us, was retained by the original lists. That would be evident from a comparison of page 48 and this page.
Your plot is 406.
My plot is a portion of that 406.
406.
28. Well, if my lot turns to page 47 and 48, the retained land and the surrendered land, the tag numbers are there. And in any event, section 33 of the forest
So you have
Act,
been only asked to appear and to clarify.
but this is a jurisdictional issue.
Please clarify that the authority can also decide on the jurisdiction. You raise these are the points only for clarification, Mr. Chatterjee.
It doesn't belong to the forest department, it's a matter of record. Then they could not have issued this.
Show that it does not belong to the forest.
It's easier to show, satisfy my law.
It's the authority. It's the best person to decide on
In
the
any event,
jurisdiction. Those line of decisions are there. The authority can rule on its jurisdiction. So you have only been asked to appear and to clarify. Approach the authority, please clarify those issues. Please say that yes, I have got this
Let
property.
us be given a hearing on this. We'll respond with our. It is already there.
You are spelling which. So what was the page? 12th of February. Date is also there.
Yes, yes. We have approached it properly. Let them give a hearing. There's no mention of a hearing in this matter. I'm sure Mr. Habib will not.
Once you give a clarification, they may accept that even without giving you trouble to attend their office.
We are also confident about that.
Mr. Chatterjee,
What keeps you are the premature application, not the premature jurisdiction.
you can clarify that issue if they want. If any decision is taken against you, if they are not satisfied with your clarification, they will be giving something thereafter. They can ask you
kindly see the last paragraph. Your reply should reach this office.
And kindly,
Along with the record of rights. So, Mr. Chatterjee, only you have been asked to produce documents.
record of rights for the tribunal petition is pending. They are not.
No, it is conversion application.
Conversion is necessary for that.
Conversion is a different thing altogether. You cannot
No, there are
convert now.
two
Now-
applications pending.
So now you are.
Two applications pending.
Till that is allowed, it's the original record. You have to produce the original record.
Original record will be of
So
the.
what is the
original-
present record of rights? Show me the record of rights. After the Estate Acquisition Act,
The original record. There is no challenge to this page 48 and 49.
yes. No, page 48 and 49 is the schedule.
Is the retained land retained by the Maharaja.
Yes, yes.
My
Show me
court
the
here-
record of rights. Mr. Chatterjee, show me the record of rights after this. Show me the record of rights. You produce that. You have been only asked.
1946 that is there.
53.
After the compromise took place in 1960.
After the Estate Acquisition
Yes.
Act, there has been vesting and retention.
This is post acquisition. Both the estate acquisition. The estate acquisition. 48 and 49.
48 and 49 is not post Estate Acquisition.
1960, 1960.
53.
Yes, this is
So,
1960.
so it's 55 is the date, relevant date. So
that is
after
there.
that, what happened? The record of right, vesting, whose interest vested, who could retain, in what capacity.
This is
So-
mentioned in the settlement.
Mr. Chatterjee, please show me the record of rights. You have been asked only to produce the record of rights. So please produce.
Produce
So-
the post 1960.
Yes, please produce. You have only been asked to produce the record of rights along with the record of rights of 406. Produce that before the authority. You have only been directed to produce the record of rights. Those are in your support. Produce them, they will consider.
These matters require explanation. Whether let a hearing be given. And if necessary, my lord,
Mr. Dalip,
what is the issue?
Milord, may I, Milord, respectfully submit? Milord, may I, Milord, draw your lordship, Milord, respectful attention, Milord, to this page 90, impute notice.
Yes.
It is very much category, not that everything is to be done behind his back. It says what Milord kindly says, notice for clarification, nomenclature. During routine patrolling, first paragraph I am skipping. In this context, it is worthy to mention that plot number 406 is a recorded forest land having Khatian number 244 under block land dimensions of the Durapur particular block under jungle classification. Having an area 1 to 7 acre with 100% ownership and your gazette notified forest land as protected forest. Any sort may I submit brother? Any sort of encroachment attempt will be evicted as per provision of section 33 Indian Forest Act. Legal prosecution will be initiated so as. Now you are directed to clarify the above matter within 12 February 2026 and also justify why legal action should not be taken against you. Your reply should reach this office prior to or on 12 February 2026 along with record of rights of Lot 406 of Murja, Ketadova, their number failing which legal process will be taken consented by so if consented by the deputy conservator for it after
only one thing, Mr. Dalip.
he is
No, you are right. He has only been asked to clarify. To bring
with
the,
reply
yes, to reply.
and to record of rights.
Yes, to produce the documents in his support. So I will direct them to do that within the time because time has not yet gone. So it's within time. There is no question of extension of time now. So he can do that. Produce all relevant materials in support of his case before the authority. And if any adverse action is contemplated, he will be given an opportunity of hearing.
It has to be Milord. How
So
can
I'm only mentioning that if any adverse action is contemplated, hearing, take that.
If there is any document.
Otherwise, they will come and say, yes, you have taken this without
Yeah.
giving me an
there could not be violation of principle of natural justice.
I'm only recording that if any adverse, if it is in their favor, it might go in favor of Mr. Chatterjee. So
Yeah.
then no hearing is necessary. So if any adverse action is contemplated against him, he will give an opportunity of hearing.
Let there be, Lord.
Yes, Mr. Chatterjee, your
Document which is adverse to my interest, paragraph 2. That should have been applied along with this.
for what?
So
Please
for
first
my-
show me your record of rights, Mr. Chatterjee.
my
Please show me
predecessor-
your record.
I can show my predecessors.
Show me that. You have not annexed that. What's the classification of land? Why did you approach before the Land Reforms and Tenancy Tribunal?
For two purposes.
For what?
Change of use. For change of
Yes.
use.
So what was the classification? From which to which? From
Needed
what is the recorded classification?
industrial use is needed. Kindly see that application.
So what was the original classification?
That is jungle classification, not total.
What was the original
Not forest, it was Ali.
Bali?
Anyway, we needed some other
Produce that
and one of the
because the entire plot was not allowed to be retained. It's a portion of the entirety.
entire.
You are wrong. Had it been so,
You started by saying portion.
To argue here.
Mr. Chatterjee, you started by saying portion. When I asked you, if the owner, what is your plot?
The portion of the retained plot. Was that
Portion?
there at page 48, right?
Portion of 406.
Yes.
I am saying that.
That is
So
why
406 is the plot.
the entire,
Portion of which has been vested. Portion is retained.
no portion has been vested.
The entire has been retained.
Yes, page 49.
Yes.
Page 49.
And where is
406
the,
is there, 127.46. This is the list of retained lands. Mildly block
where is the list of vested lands?
It is there in 2 pages, Manoj. One is the original settlement deed, paragraph 7, page
Show me the vested schedule.
that is page 50.
Page 50.
That is reflected
routine for taking possession.
It is reflected from paragraph 7 of the settlement. Manoj.
No, where is the order of retention?
That's
not there, Miller.
There's a reference.
Nothing
there.
of the sort.
The settlement is there in paragraph 7, page
Please.
47. Page 47.
Read the code in the
No, I'm not misleading the court in any manner.
Mr. Chatterjee, you produce all your documents in your support.
Page 50 is the prototype of page
Any
43.
adverse action is contemplated, you will be given an opportunity of hearing.
George, well, kindly see page 47, the vested lands, page 47. That is the settlement. Mr. Ghalib will not howl at you.
All right.
Not at all.
You produce the documents. Produce those documents, then we consider that.
They'll also supply us the documents which they are relying on.
I think it's available in the website.
Even
Bangla Bhumi is
even
available.
Even there.
If it's available, please see. If you want anything, you can approach your authority.
Document, ROR.
Bangla Bhumi will be
Bangla
getting
Bhumi, Dage Tattva, everything is
will
clear.
get everything.
But it should have been there and annexed to this notice.
You go for it, you are claiming it, that it is your property.
If you want
It's not a
something,
forest land anymore after 1960.
you know, the petitioner It is taken away. I'm coming after 5 minutes.
Great.
Right, so here, on behalf of the petition, that the matter was mentioned, but considering the urgency,
Yes.
we have served the respondents by mail. This, I'll put it in
Which
affidavit,
is the respondent?
but the respondent is
Kolkata
the,
Corporation.
but, it is the fisheries, Directorate of Fisheries. But,
Directorate of Fisheries, I
yes,
think the
I tell
state
you-
can appear.
State can appear, yes.
Yes, Corporation,
Kolkata Corporation has been served, your lordship, kindly note. Both a hard copy as well as by mail, this is to mail.
Mr. Dey, can you appear for this case?
I will give a copy.
You have an extra copy.
Yes,
And Mr. Cobb, can you send someone of your juniors, anyone, Mr. Ghosh or anyone who appears for the corporation, follow Ghosh or anyone who appears for the KMC?
thank you, sir. Now, I am the owner of premises number 49/1, Prince Ghulam Hussain Shah Road. Now, Lord, this is a property, it's a fairly large property, about 2 bighas of land is there. Now, Lord, there is a water body inside the property. Now, Lord, on 1st of September, Lord, I receive a notice which is planted in my property. Kindly come to page 9.
Page 9.
Yes. This is a notice, Lord, issued by the competent authority, municipal commission.
Is an authority under 17A.
17. Now,
Yes.
Lord, it says, whereas on inspection it has been found that the water body, the description of which has been given in the schedule 1 and 2 below, has been kept in ill-maintained, it should be, condition, resulting in destruction of fisheries and environmental degradation in contravention of the provisions of section 17A of the West Bengal Inland Fisheries Act 1984. Now, Lord, just pausing here for a moment, there is no allegation that I am trying to convert the water body. The water body is there, ill-maintained. That is the ground. And whereas the owners, the person in occupation of the said water body, were asked to show cause through newspapers, namely Songpad Pratidin and Echo of India. I don't think, Lord, anybody at all, Lord, reads these papers. On the 7th,
Songpad Pratidin may not be so widely circulated, but
Echo of India, I have never heard. I've never heard. And Lord, Songpad Pratidin, Lord, I really, Lord, do not know, Lord, how many people, Lord, read that.
may not be that much wide circular.
And Lord, my name is in the mutation. My name has been mutated. I am recorded owner. But
Now, what has been directed?
notice is served, Lord, through newspaper. No notice to me. 7th February, pasting the notice in conspicuous place at site as to why the management and control of the said ill-maintained water body would not be taken over. Now, Lord, kindly mark this. It was pasted in at site. Which is that site? I will come to it. In conspicuous place, the said ill-maintained water body would not be taken over by the competent authority, and the owners, the person in occupation, was suggested to restore the water body and its embankment to its original position within 30 days from the date of the publication of notice under section 17A of the West Bengal Inland Fisheries Act 1984. And whereas the owner's person in occupation did not take any steps to that effect for restoration of the water body to its original position within the stipulated period, and whereas for carrying out the purpose of the said act, it has been considered necessary and expedient to take over the management and control the water area, including its embankment, detailed description of which has been given in
So
the
they have invoked 17A.
Now, Lord, let us see, Lord, whether 17A could be invoked for this purpose. And that too, without notice, without giving me a chance, Lord, for the purpose of, Lord, restoration or whatever. Lord, I have to be heard. I am the owner. Somebody can't just enter into my property and say that I have taken over management one fine morning. Now, Lord, what happened is that, Lord, kindly come to now.
No, you have been only asked to show cause.
No, they have taken over possession. Kindly see.
No, this says as to why would not be taken over by the competitor. Where is that notice that it has been taken over? Where is that?
My notice, this is one. Then Lord, please come to Lord, I prefer an appeal against this notice. I prefer an appeal. Kindly see the order of the appellate authority, which is at page 200 and
Is the divisional commissioner?
is the divisional commission. Yeah, section 18
Yes.
under the Fisheries Act. 243. If your lordships will not kindly come to
243. Yes.
but the order must be yes. Kindly will not come to page 244.
Yes.
Third paragraph. Documents submitted by the appellant in support of his claim of ownership of the fund have been taken on record. Report submitted by Assessment Collection Department, Calcutta Municipal Corporation, and the report submitted by Assistant Director Fisheries have been taken on record. The learned advocate for the appellant argued that the notice under 17A is bad in law as the SSC number mentioned in the notice is wrong, non-existing. Hence, the order of taking over of management and control is also bad in law. They also argued that as the notice was not served upon the appellant being owner of the plot, the subsequent order of taking over management and control of the plot is not sustainable. Moreover, the nature of the plot as mentioned in the conveyance in land is land and not a pond, so the subject plot does not come under the purview. Then representative of the Kolkata Municipal Corporation submitted that after receiving complaint, this complaint was never handed over to me, regarding a pond near premises number 47 by 7. Kindly will not mark the premises. I am not owner of 49 by 1. 47, 49 by 1. And Lord, my mutation records will show that I am the owner of that property. 47 by 7 Prince Ghulam Muhammad Shah Road in ward number 95. An inspection was conducted on 20th December 2024 without notice to me. And the water body was body with embankment was found to be kept in neglected condition, leading to environmental degradation. A notice under 17A of the Land Fisheries Act was issued on 7 February 2025 and published in the newspapers. And also notice board as was installed at the site. Site means 47 by 7. Kindly note see, it says that near premises number 47 by 7.
No, it says near. It
Near.
does not say it's 47.
And it does not say 49.
No, it does not say, but it's
Near 47 by 7.
yes.
And then it says installed at site. At
Yes.
site. Whichever that site is. Ownership of the water body being unknown to the KMC, the notice could not be served upon the owner. However, after installation of notice board, some objections were received at their end from a few persons claiming to be the owner of the water body, and the said notice was also served.
Who are they?
God alone knows. Not upon me. I come to know on 1st September. I prefer an appeal.
No, those objectors claim to be the owners.
That must be in the records. I must be given a chance to deal with that. I don't get any opportunity at all. Kindly will not see how the order proceeds. It's really not. After waiting for a substantial period when no restoration was done, the competent authority in exercise of power conferred by subsection 2 of 17A of the West Bengal Inland Fisheries Act took over management and control of the water body with effect from 1st May 2025. 11th May. 11th May, there was nobody. I was occupying the property. On 1st September, somebody put that board. And that's how I come to know. From the report dated 29th October 2025 submitted by Kolkata Municipal Corporation, it is clear that there is a gross ambiguity over SSC number of the plot. Kindly will not mark this. The pond SSC that has been taken over by the competent authority is currently recorded with an unknown owner. While the recorded owner, 49 by 1, kindly will not see now my premises comes, was
You are
Calcutta.
Calcutta Credit.
Yes. Which is, as claimed by the applicant, now owned by Silica developers. This is now become Silica developers. The Silica is the petitioner. So and so. A series of several merging and demerging procedure of companies under the Companies Act as per their submission. But the latter premises could not be traced physically by the respective section of the KMC during inspection of the site.
What is the later premises?
I don't know. 49 by 1 is my property. I am in 49 by 1. What is the later premises? Later premises must be 47 by 7.
All right. Yes.
Again, the dearth of definite information on the ownership of the subject plot limits the scope of KMC to serve notice upon the owner of the pond as envisaged under subsection 10 of section 17A of the land is so and so. Now, my lord, kindly see page 9. Your lordships would not find this averment there that the landowners are not traceable, therefore we are putting up public notice. Substituted service, therefore, my lord, that there has to be some finding that landowners can't be found. I am, my lord, in the record of the municipality, I am paying tax. There can't be any ambiguity with regard to my not tracing me out. Then, Lord, please come to Lord. It says again, dearth of definite information on the ownership of subject plot land in scope of the KMC to serve notice upon the owner of the pond as envisaged on section 10 of section 17A of the Inland Fisheries Act 1994 and subsequent rules. As per field verification report dated such and such submitted by the Estate Director of Fisheries South 24 Calcutta, the subject plot is a water body with approximate 2386 square feet meter area. According to the report, the water body is fully covered with floating weeds and heavily polluted with domestic garbage. The existing condition of the water body renders it unsuitable for pisciculture. Now, Lord, kindly mark this. It is if it is unsuitable for pisciculture at present, then Lord, there is no question of invoking power under the Fisheries Act. However, it can be made curable, culturable with proper management and maintenance. In the light of the conflicting statements regarding nature of the subject plot, the appellate authority preferred to obtain a report on time series analysis from the Fisheries Mapping Project Unit under the Department of Fisheries, Government of West Bengal, to ascertain the nature of the subject plot before concluding the appeal. Now, my lord, I have not been given a copy of this report. Whatever report has been called for, I find from the order itself. Report of the Fisheries Mapping Project Unit reveals that the physical nature of the plot in question has existed for the last 15 years. The report and satellite images confirm that the plot was a water body with an approximate area of so and so hectares, so and so. Observation of the appellate authority, the plot in question is physically a water body, irrespective of its land classification in old records. According to submissions by the representative Environment and Heritage Department of the Municipal Corporation, both the water body as well as embankment is kept in ill-maintained condition. As per field verification report submitted by the Estate Director of Fisheries, South 24 Parganas, the water body is fully covered with aquatic weeds and heavily polluted with domestic garbage. The report of the Fisheries Mapping Project Unit also proves beyond doubt that the water retention in this whole plot is perennial in nature and not temporary, and definitely it is over 6 months. It is clear that though the appellant claims the plot to be land, physically it is a water body and that has been kept ill-maintained condition and that can be utilized for fishery if properly managed. So the appellate authority is of the view that the physical status of the subject plot meets the criteria for intervention under the West Bengal Inland Fisheries Act, and the notice under section 17A of the Act for restoration of the water body is justified. Now, Lord, after elapse of more than 3 months and servicing the notice upon the person who claimed to be owner of the plot, the competent authority passed the order of taking over management control of the water body with effect from 11th May 2025. This order is also not communicated to me. This appears to be justified on the part of the competent authority. So, Lord, the appellate authority holds that there has been a proper notice, and Lord, the taking over management is justified. The inquiry report of KMC establishes, this is again, Lord, not within my domain, establishes a high likelihood that physical pond with SSC number such and such may be the same property. Kindly, Lord, mark this. Recorded under the appellant's SSC number such and such, based on the extent of land, approximately 2 bighas, and the absence of any other similar size open land in the locality. This indicates a lingering dispute over ownership of the property. Now, Lord, who's not disputing? I don't know. Identification which may be pursued in a proper forum rather than the appellate authority, since property identification and settlement of ownership dispute do not come under the purview of the appellate authority under the Inland Fisheries Act. The above finding on property identification are for the purpose of current administrative action only and do not prejudice any future civil litigation regarding the appellate title to the land. Thus, based on the submissions of both sides and the physical status of the water body, the decision of the competent authority is upheld and the appeal is dismissed. The further appellate authority would like to add that very purpose of section 17A is conservation and proper utilization of water body for physical. Now, Lord, I don't give no notices for restoration. If that any restoration is required, that is not received. It is admittedly, it is unfit for pisciculture. That is also held. And my lord, power under 17A is invoked. But now let me show my lord, your lordship, that my lord, I am the occupier recorded in the record of the KMC. Your lordships may kindly come to page 67.
Any information about Mr. Ghosh or
Yes.
I believe my lord is coming.
yes?
Page 95. Kindly come to page 95. Lord, this is the assessment book.
95.
Yes.
Is it Taliganj?
This is Taliganj Tax Department. Yes, this is Prince Anwar.
Extension of Prince Anwar Road.
Please come back to page 65. That was not Calcutta credit, as your lordship seen, sir.
Yes. Calcutta credit.
Yes. Then Lord, please come to page 65 also. This is your Calcutta credit owner, as your lordship seen that at the top.
Yes.
SSC number is there.
Yes. 49 by 1.
Yes, and 49 by 1 premises number is also there. So, Lord, in so far as the tracing of the owner is
49
concerned,
by 1.
49 by
Is
1.
it a bare land or a land with
It's a
structure?
land with water body.
With water body?
Yes. And my water body, now, Lord, if your lordship sees the picture, now what has happened is, kindly, Lord, see the last connection. P14.
Page
251. But the impediment works has started. Somebody has entered my property. They have started spending money. Kindly see 251. Kindly come to 252. This is the plaque which is being pasted in my property. So, Lord, kindly see section 17A on which the reliance has been placed. Kindly look at section 17. Right.
Which volume?
9.
Volume 9 is taken from the West Bengal. Okay.
Lord, kindly come to section 17A. Kindly see the heading, part to conversion of water area, etc. for other use. No person shall put any water area, including embankment measuring 5 cutters, hectare or more, which is capable of being used as fishery, or any naturally or artificially depressed land holding measuring 5 cutters, hectare or more, which retains water for minimum period of 6 months in a year to such use other than fishery.
5 cutters, I think that has been omitted now.
I see.
This is,
my lord is looking at the new edition.
Yes, this was omitted with effect of Amendment Act of 2008.
I see. Yes. Yes, your lordship is right. I am
So
looking
now
at
the extent is no more there.
yes. No. Any.
Any.
But Lord, the the requirement is put any water area including embankment which is capable of being used as fishery or any naturally or artificially depressed land holding which retains water for a minimum period of 6 months in a year not used other than fishery as may result in abolition of fishery at the jurisdiction of municipal corporation, etc.
So
But this is-
basically, naturally or artificially depressed holding more than water for more than 6 months.
Right, but not, I have to use it for purpose other than the water.
Yes.
And your lordship sees the language used that it is capable of being used as fishery. There is no allegation that I was trying to convert the water body. There is a finding that it is not capable of being used as a fishery. And in spite of that, I am not being given any notice that you need to clean up the pond or you need to clear the pond. But I can't use my property like this. Somebody can't come and take over. 17A is not for acquisition of anybody's right. Number kindly see B, fill up any water body, water area. This is also not the case. C, within the jurisdiction of municipal corporation or municipality, divide any water area, including embankment. This
That is not the case.
case, any purpose so and so, then provided that restrictions contained in A to C shall apply in respect of any measured 5 cutters or so and so or more falling within the jurisdiction. Then, if the competent authority on receipt of an information or on his known motion or otherwise, here on the basis of the complaint. So, the complaint, whoever has made the complaint, I must be made aware that against my property there is a complaint. Any water area including embankment, naturally or artificially depressed land
So
holding.
it can be done on own motion also, but this satisfaction is required either on complaint or
complaint.
or on own motion.
This satisfaction has to be recorded.
Yes.
That the test is that whether I am putting it to use for any other purpose. Apart from ill-maintained water body, there is no other allegation.
Show me the order of the competent authority.
That is the order that we have, page 9. I don't have the copy of the order of the competent authority. It has never been served out.
But why did you not ask for that? Because you have preferred an appeal.
In the appeal, we have applied for the certified copy. We have preferred an appeal, asked for the copy. It was not given.
Appellate authority?
Kindly see from the order of the appellate authority. And page 71, your lordship will find my application is there. Page 71. I applied for a certified copy on 2nd September 2025.
So according to you, the only order is that extract portion.
Extract portion which is put up in the property.
Page 9.
Page 9.
What is the date of this order?
That date is 11th May. On 1st September, this is what comes on my property. And before that, they say that they could not identify the property. Which property the water body belongs, that also they could not identify.
Yes, Mr. Ghosh. Are you appealing in this matter?
So I, initially in one matter under this, the petitioner's name will appear. I don't know what is the fact in that case. In that case, I have not been briefed. I have not been instructed. So,
can you appear in this matter?
I can assist you.
Because they have, I think they have filed yesterday, day before yesterday. When have you served upon the corporation?
Corporation for service.
Mail service
Yesterday, I think the mail has been served. And therefore, yesterday, the hard copy.
The hard copy was served. You can appear. Do you have an extra copy?
Yes, I.
So, Doctor, you are giving your copy.
No, I copy.
He is high tech.
They are now ready with that another papers. And we used to take up the hard papers.
Mr. Ghosh, only the scope of which Mr. Kaur was now highlighting that some orders have been passed by the competent authority with regard to vesting of the or taking over the management of our water body on certain allegations. According to Mr. Kaur, no notice was served upon him. It was only affixed on the property. So he came to know the order is dated sometimes in May 2025. He came to know, according to him, that was put up sometimes in the month of September. No certified copy was not with him, though he prepared an appeal. The appellate authority affirmed the order of the competent authority, and also some materials were taken into consideration by the appellate authority also. Some reports, some inspection reports, other maps and other things. The sum and substance of Mr. Kaur's argument is violation of the principles of natural justice. The materials which were used against him, those were not supplied to him prior to the hearing before the appellate authority, and so far as the competent authority is concerned, no notice, nothing, no opportunity. So that's also. So basically, he is on the violation of the principles of natural justice. So now, what is the interim order which you have
Lord,
taken?
I am saying
Page 60.
Now the management of the water
I am
body.
submitting, my lord, when the matter before the primary authority, then before the appellate authority. Now he is challenging, as I understand, all the order of the appellate authority is under challenge. Therefore, whatever the position was there at the time of taking over the, of course, my lord, definitely notice itself says so that the management and control has been taken over.
Yes, yes.
Now, on that score, what the matter had went before the appellate authority. The appellate authority passed the order. Therefore, in this case, right moment, in my humble submission, there is no scope for interim order.
Let me see what
Right.
interim order he has paid for.
F and G. Page 60.
If is execution, execution is in effect taking over. Taking over has been done. That cannot be now unsettled at this by way of an interim order.
Lord,
Second is carrying out any construction or civil work. Please do not do anything with regard to that, because which you have taken over without hearing
But
both of
only
you,
I'm
it cannot be again.
I only do this thing each after they take
When
over the
can you take
management for
instruction?
one of the reservation and maintenance of that water body. It is not our object, my lord. The otherwise, my lord, to
No. One thing is to
preserve and maintain.
preserve. Another is beautification. Nobody knows boundary wall construction, allied activities. If this order goes, he is at liberty to keep. Of course, he cannot. He has to maintain that water body. Boundary wall, how he will maintain another thing if this order goes. So do not change the nature and character for the present.
Whatever the situation today, my lord, that
Because
will be maintained.
taking over of the management, that cannot be unsettled
Whatever the-
without by way of an interim order.
whatever the position
But how
today,
soon can you come back with the instructions? Because Mr. Kaur's simple submission is that
I follow, my lord.
reports
I
are
can,
not given,
my lord,
so it can be relegated to the appellate authority with those materials.
Relegated to the competent authority, because I must go back to the competent authority.
Well, I can instantly
Well, I am-
answer to this, my lord, but I am not, my lord, submitting
Please
without,
take
my lord,
instructions.
without having a discussion with my authorities.
Yes,
But I may come back in the next Thursday.
next Thursday.
Yes.
My second point is that Lord, assumption of jurisdiction under 17A was wrong.
Yes, that I will
That-
consider. Let the status quo be maintained. Till when can you come back? Thursday?
Let me come back Thursday. If necessary, then I'll pray for
Instead of Thursday, can you choose any other day? Because Thursday the cooperative ta call Mongolbar. Na? Thursday, can you give
Friday.
suggestions?
Friday.
Friday, I think a division names is there.
Then you'll be
Wednesday, can you come back?
this Wednesday, and then Wednesday week will next.
Wednesday week.
But prayer G, Lord, if your lordship can.
Yes, yes. Status quo includes prayer G.
In respect of construction.
Status quo as it is.
My problem is that, Lord, today, what is the status quo that is not before your lordship except for those two photographs. That's why I'm saying, Lord, kindly, if your lordship restrict it to restraining them from making further construction, any civil work, etc.
Not to change the nature and character, not to change the nature and character, I think will suffice. Mr. Ghosh, don't change the nature and character. Please see, they are G and
Yes,
H.
and not to transfer. They
I
under the
I
Fisheries
don't know
Act,
what is
they
the
can
exact
transfer.
position right now.
And
That is the reason I'm saying, well, whatever the situation as on this day, we maintain. Because
injunction is as on
You
this
know-
date from 1241, not prior to that.
that's right, you should make the order.
Yes.
Because I
I'm
don't know
saying
what is the
don't change the
position.
nature and character, what has been done.
And your advice was kindly will not appoint a special officer who can go and inspect and file a report. That will ensure Lord the status quo whatever it is that
Economic service taken out. Yes, yes.
Order number 78.
Article. The petitioner is also restrained from yes, call the next matter.
Better you know, but please to direct me to file a.
17.
17.
Yes, yes. Report.
Direct purchase policy, my lord. My lord, they are now, my lord, with the editing. They are not, my lord, agree to
They are not agreed to.
give that editing, my lord.
Then 2013 Act, please pay. Then you have to pay under 2013 Act. Because unless there is an offer from you, what they will accept?
My lord, I can offer, but that is that your lordship said that within 4 months.
Has to be, otherwise it's no offer at all. It's no offer at all.
They did not. Then your lordship advice, it is not possible. Every day I am taking time, my lord, but they did not. Within 4 months, it is not possible to give the form of evidence.
Within how much time? Mr. Dey, if you have to give a proposal, you have to say within how much time. It cannot be as vague as that. You want to purchase, then it shows that you do not have any intention.
I have the intention. I have only thought that is that there, my lord, very much.
So if it is not 4 months, within how much time? But you have to conclude, you have to take a stand on epidemic.
Then my lord, give me a. My lord, without epidemic, if your lordship said, then my lord, I can. But with
Without
epidemic,
epidemic.
you can give me another chance, my lord, I must try my little.
So I'm keeping it in the next week. So if not 4 months, please tell me within what. Otherwise, it's vague. After that,
Next week, my lord,
and I do not know whether in the other
Lord,
matters you have complied with or not.
my lord, give me 2 weeks time. That's because, my lord.
On the prayer of Mr. Dale Arnett, additional government.
The last section, my learned friends furnished a report, submitted a report. I have perused the report.
Yes.
And it appeared from the report the ultimately state of it is the land grabber. Lord, kindly see the
Land
report.
grabber.
Yes. With an intention to grab my land, furnish this report. Kindly see the report.
Yes.
In connection with the above noted subject, I humbly submit the status report in connection with the petition number so and so in the matter of Anjukti Shah of the state of West Bengal and others is furnished. As per LR computer database record, Anjukti Shah, daughter of Narayan Chandra Shah, the recorded right of LR plot number 378 with area of 022 acre of the Mauja Palasipara with JL 42, but in information from a special land acquisition officer Nadia received by memo number so and so, it is found that 12 acres land of the LR plot 378 of the said Mauja has been acquired by the LA case number 9 BRP 7475 for bus land. Then Miller can come to page 15 of my writ petition.
No, what has been, your property has been acquired.
No.
What is your property? What is your plot number?
Plot number 378.
Kindly come to page 15. Record of right.
378.
Yes. And also the self-same authority submitted a report where he admitted that the land belongs to the
No,
petitioner.
378. Status of acquisition is available from the end of the LR plot number 378 with acquired area.
Yes.
378 has also been acquired.
How much area? How much area?
With acquired area 0.37 acres.
Point 12.
No,
point
this is 0.12.
12.
Yes.
Ah,
No, first second. Yes, 0.12.
I have stayed in the report, first paragraph it is mentioned. Then come to page 15 of my
Of your
requisition.
requisition, yes.
Total area of land in plot number 378.
Yes.
22 decimal. No. Total area of land 91.
Where are you getting 91?
JL number, মোটটাকে সঙ্গে in their report, I have found it in their report.
Yes, show me where is 91.
At the top, report, second page of the report.
Second page
Of the report.
Yes.
Total area of land. How they have come to the conclusion that my land has been acquired. Apart from that, my lord has got it at top.
Yes, 378.
Plot number 378.
Yes.
Total area of land 91.
91.
My land is. Then come to second.
What is your name?
Anjutpi Shah. Third page, fourth page, last page of the report.
Last page.
Last page of the record.
Yes. Anjutpi Shah, 22 decimals.
22 decimal. That has been recorded in my name. I have purchased the land in the year 2022. And
22 and acquisition proceeding of 18.
but my land is 2022 out of 91. How we have come to the conclusion that my land has been acquired? Apart from that, initially I have filed two petitions before this honorable court for removal of unauthorized encroachment in front of this land. And in the said matter,
No. What is your stand? Your stand is it has not been acquired.
no,
Then why have you come before the court?
because they have affixed a notice board.
Where?
In my petition, I have annexed the same
Yes.
photograph. Page 30.
30.
Yes.
No. From here it cannot be ascertained on which plot.
And if your lordship kindly come.
Photograph it cannot be ascertained at which plot.
That is my plot number 378. Plot number
Kindly read the
378.
presentation.
They have mentioned plot
Kindly the
378.
case represent page 33.
Page
What is
33.
each case? What is each case?
Yes.
I, the undersigned, being the husband of my wife, Anjutpi Shah, who is the absolute owner and possessor of the land situated at 22 decimal, the said land has duly been recorded in our name on the basis of the purchase and possession. Suddenly, the following persons, such and such,
Yes.
They
It's a
are
civil dispute.
Civil dispute.
Private dispute.
Private
Go
dispute.
before the civil court.
civil
No.
court.
Civil suit filed by the private respondent.
Yes.
Being an unsuccessful in the said injunction petition,
Yes.
thereafter in collusion with the state authorities, after rejection of the said injunction petition, the said persons along with others on 12/11/2024 hung up a board on my said right to land that the said land is a government land. Kindly see first, second, third, fourth paragraph.
Yes.
The said land on my ownership land forceful and illegal without any order from the competent authority with an intention to grab my land by breaking boundary wall forcefully and illegally without any care of the law of the land. That my staff tried to resist those persons from hung up the board on my wife's land,
The
but
state persons have hung up a board.
Hung up.
How are the respondents?
respondent
State
took
is
no-
responsible.
respondent took no steps. That state is still sitting tight over the matter. They have no duty.
State has no
It is
duty.
your property, but yes, Mr. Mahato, your report says it's an acquired land.
Yeah,
But-
Record about 12 decibel out of 20.
But if it is 12 decibels have been acquired, what's the extent of the
My lord,
plot?
if you are
And not only that,
kindly see the map.
The record of rights?
Acquisition map has been given, my lord, kindly see the
Yes,
map.
yes. What is the total extent of that plot?
22 decibel.
Total.
Total
9
9
to 1.
If you are not kindly see my lord, my report,
Yes.
the map is given, which is the acquired portion. And the board must,
In your
if there is
report, which page?
and they have not denied that they have not hang up the board. No, I mentioned. My allegation is that hang up a board by the
Private for the private respondent.
private respondent along with the
Private respondent.
state, along with the state authority.
This
Along with,
suit is pending,
no, suit is pending, injunction is.
so approach the civil court for removal
But
of that.
state authority, I am unable to enter my land.
Civil suit is pending, please file an application there for removal of that board.
Yes.
If the private person's civil suit is there, please
And
approach
kindly
there.
record that the petitioner's land has not been acquired.
I am not going to record anything. It's your case that it has not been acquired. They are saying it's acquired. I will not go into that whether it's
No.
acquired or not.
What is their submission? They
Your
have acquired
submission
or
is
not?
that it is acquired. You are relying on the record of right.
I am
They are
relying on the record of
they are
rights and
saying
that
it's
the total
acquired.
area of land 9 to 1
They are
decimal,
saying
out of which only 12 decimal have been
they
acquired.
are saying a portion of it has been acquired.
Acquired.
And who are the awardees, Mr.
No awardee list, no awardee
who
list.
are the
Kindly
awardees?
see the report, first phase, no awardee list received.
My lord, the record of rights is not corrected.
No, no. Record of rights are not on the record of rights. In whose name the award has been published?
My lord, petitioner, my lord, the awardee list, my lord, is an AFT.
My lord,
Why?
Paragraph
70 board,
Sir,
75.
The name of the
Mahato,
awardee.
if you have completed the acquisition proceedings,
If you also kindly come paragraph 3
yes,
of my report,
yes,
the awardee name of the recipient of awards are needed to initiate a proceeding for the award correction of
that is for correction.
Yes.
That's a different thing altogether.
Well,
So I'm not on the correction. Do whatever you want in the correction. I want where is the award list.
on the-
Unless you produce the award, his predecessors might have received. He can
No, I
chase
have,
his predecessor.
I have purchased in the year 20.
my lord,
I have purchased.
my lord,
So your vendor, after taking compensation, if you have transferred,
But
he chases your vendor.
that
if
is
you
not,
are not
This
kindly,
is
Lord,
an
not
acquisition
happened.
proceeding.
if you are not
kindly
kindly
see
come
the pen drive.
Sir, this is an acquisition proceedings of 74-75.
I have seen.
So
But
your vendor,
their report, assistant engineer submitted a report.
your
No, no, no,
vendor
the BLR.
might have
BLR
sold
has
after
come.
taking compensation,
Not the
taking advantage of the wrong recording.
BLR
But
has
what is going on, kindly see the pen drive. The petitioner on 12th January went to a land. At that time, some person registered and tell him to kindly to come at the party office to settle the dispute. This is the
Mr.
situation.
Mahato, please.
This is the situation.
This is the copy of the award.
But actually, my lord, this is the relating to the wrong recording. That is why, my lord, I got the report from
No,
the director.
it is the allegation of wrong recording.
Yes, that is the case.
What is this
Where
fair?
is the wrong recording? What?
My lord, my lord, all these plots have been recorded for past 10 and my lord,
What is submitting? I don't understand.
and my lord, the sketch map is given the LR acquisition sketch map. The question.
Where is the representation given to the authorities?
Page 33 starts from page
Yes, my lord.
Page
kindly-
33.
Yes, what are the representation?
I have made representation to all the
Yes.
authorities.
What are the contents in the representation? See. Those persons from hangar.
Yes.
the whole.
So you approach the civil court. Asun, the petitioner.
Directed Mr. Dave submit report.
Yes, yes. Report, Mr. Day. Ready?
Yes.
Have you served a copy upon them? Please serve a copy. I'm taking about 2 p.m.
And not I have not gone to the report for them. Mr. Dave, it says that
During the recess, we cannot go through, Mr. Ghosh. There is one matter, I think, in the original slide. After that, it will be taken up.
I've been virtual.
Why?
Yeah.
That cannot be a ground before the High Court.
No, I've been virtual.
grant us some opportunity to deal with this by as for affidavit within 3 days.
Yes,
And
sir.
then we'll have the matter.
Affidavit.
Yes, exception to the
My
law,
lord.
because Lord, they have, my relation said that they have acquired the entire plot, which is not a fact. They have information that part of the plot has been given and thereafter 3 bata plots have been recorded, 2 in our names and 4 decimals in the name of state.
All right, then you want to file an exception
Yes,
to this report.
yes.
All right.
Report says, my lord, the entire land has been acquired and disputations are not accepted in complaint.
That was not, that was the thing.
If you want to file an exception, let him do that. The report. See, this is not the report.
Yes, my lord, entire report is there, but the order sheet is first, my lord, after that. In the form
So
of
report is
that
the
was
next
not-
document. No, this is not the report.
My lord, report, in the form of report, that was not done, my lord. The first, my lord, I give the.
So I'm recording, it's not the report, a bunch of documents.
Yes, sir, bunch of documents.
A bunch of documents.
Twenty 21. Affidavit is ready, but the officer will come tomorrow, my lord.
20 and 21.
My lord,
Mr. Ghosh is seriously opposing you.
No, I am not.
No, that will not.
He will not.
He will never.
He will never oppose you.
No.
Why?
He will আমাদের বলে আছে কি?
What do you want?
Well, if we apart from tomorrow and there are some other if I understand.
Next week you want?
Yes, I will.
I direct you to file report.
Yes,
Yes,
yes.
report
I was directed to file an exception, complaint.
Oh, exception. Then some more time is
Yes,
necessary.
my lord.
The time Mr. Mahato, the time is over. It's extension is necessary.
Time is
The
over.
time report in the
In the
form
form of evidence.
time to file.
Orient site item number 1.
This is my application.
Who is opposing you?
No, no, the last occasion Mrs. Noel Banerjee was appearing. She had sought for an accommodation.
Yes.
The fortnight back.
Yes. No.
This pertains to the appointment of an arbitrator under the West Bengal Premises Requisition and Control Temporary Provisions Act 1947.
47 Act.
Yes. Under Section 11. Page 20, Miller. Section 11. Matter has a checker history.
Section 11.
Section 11. My application, the provision under consideration would be Section 11B.
Yes.
And we will also see Section 11G. That's the next page, Muller. That Muller, nothing in any law for the
11.
11G.
Yes.
The next page.
Yes.
Nothing in the law for the time being in force relating to arbitration shall apply to arbitration on section. So, Muller, this is the self-contained mode.
The Arbitration Act will not apply.
To say I'll respond on another.
Why?
I have a mention because I have a mental ability issue also.
Where is the mental ability?
Yes, I should do that first. No, I understand. And let him at least start what he wants. I want to say, today the petitioner, they have already received their compensation. Now, after receiving and accepting,
What is this is a writ petition? What is your prayer in this?
he wants the appointment of arbitrator for adjudication of a compensation is already received. That is not available to him under section 11 of this.
That cannot be a question of maintenance.
Yeah, that's why I said he will say this. So,
That cannot be a question of maintenance. Whether I'm
It's about the conclusion. Yes.
No, the fact remains.
Respondent number 1 to appoint an arbitrator.
Yes. Let me take the facts.
Yes.
Three portions.
You are representing the state.
yes.
Yes.
Three portions of this premises, being premises of a casting place, was requisitioned under this act. The requisition continued. Thereafter, steps were taken to acquire the land in terms of the Land Acquisition Act, Section 4, Section 6. What happened thereafter was the acquisition proceeding lapsed in view of Section 12. Then, the Land Acquisition Act, because they could not publish the award within a specific time period.
11A, I think.
11. I'm sorry, 11.
That is why I thought.
No, it's 12 years, but 11. So that lapsed. So we took a writ petition. In the writ petition, an order was passed, which is at page 23 of the application. It's annexure P1.
Yes.
Justice Tandon's order of 10th of August 2018, page 23.
Now, what is the direction contained here?
Kindly see the relevant portion would be at page 33.
Yes.
Let's see, the paragraph starts with, it is just thus manifestly clear. I'll take it the third line. Since the extended period under proviso 2, section 10B of the Act has also expired in the midnight of 1992, the possession of the corporation is palpably wrong and or illegal, and therefore is required to be given back to the petitioner. What happened, after taking possession of the property, this was given to the Kolkata Municipal Corporation for running the election authority. Page 34.
Yes, what has been done after this?
So this was done. As usual, but they did not do anything.
No acquisition.
No, there's no acquisition. So we'll levy the contempt. We would kindly see after this order was passed, page 36 is my representation. 36 will kindly see
where I say, my lord, at page 37, I say that this is the rate at which you should pay me compensation. Because my lord, admittedly, what happened is, prior, my lord, till 1989, I had initially received the compensation in terms of an order passed by the district judge, who was appointed via an order passed by Honorable Court in terms of section 11. So till 89 we had received. So this was something beyond 89 for the period subsequent to 1989. So Justice Tandon's order. So I make an application saying that this is the rate at which I should be paid. They don't do anything. I levy a contempt. Would kindly see, there's a supplementary affidavit, Mulot. Kindly takes up page 8 of the supplementary affidavit.
Supplementary affidavit. Is the order passed in contempt?
Yes. And this is the order passed in contempt.
Page
8. At the very outset, Mr. Ghosh, learned advocate appearing for the alleged contempt number 2, submits that Khalil Ahmed, who was the erstwhile Municipal Commissioner, is not holding the post now. He further submits that Vinod Kumar has joined the post of Municipal Commissioner and instructions to appear. Leave is granted. This correction is done. Now we'll kindly see this. It is indicated at page 9. It is indicated in the affidavit in opposition that pursuant to the order and judgment dated 10/8/2018, the rent compensation has been determined, which is annexed to the instant affidavit in opposition. It is pointed out that said rent compensation has been determined till the month of March 2019, when in fact the possession was returned to the petitioners by the KMC on 13/1/2023. So, in terms of the Tandon's order, I was supposed to get the compensation till 13/1/2023. This is the first tranche that they say they have determined it till March of 2019. Now, it kindly takes the next to next paragraph. In view of the above, the respondent number 1 is directed to take further steps for determination of the rent compensation and on and from month of April 2019 till 12 January 2023 within 2 weeks for the balance period. Then it kindly comes to page 18.
1/8
of the supplementary affidavit.
The final order.
No. 18 is a communication. So they had determined this in 2 tranches, one till 2019 and one subsequent. This is with regard to the first tranche. Now, pursuant to a letter which appears at page 17, I write to them on 31st March 2023, saying that kindly cease. Please note that the amount of 296 is on account of compensation, occupational charges.
31st of March 2019.
Yes, most important last paragraph. However, our claim in such regard is contained in our representation dated 11/10/2018, which I showed initially. That was the representation dated 11th of.
So without prejudice, you received.
Yes. Now, kindly sees the next page is page 19 and page 20. Kindly sees the date on which this amount was disbursed. Kindly sees the date of the check on page 20 is 4th of April 2023. That is subsequent to my letter of 31st of March. So they were aware of the fact that I was receiving the money under protest. They were aware. Now this was the first tranche. For the second tranche, kindly takes up now page 25. This was pursuant to a letter which appears at page 24. So this is for the period 1/4/2019 to 12/1/2023.
So according to you, you are aggrieved by the determination made the amount without or on protest. So you want an adjudication on that.
No, I bow down. This is the summons substance of yeah.
Yes.
That's all. So he says he has received and he wants adjudication, rather revision of the amount that he has received. Because the amount he has already received. And kindly see his prayers, in the writ petition.
Yes.
Whether, my lord, this is how what he wants, my lord, can be done. Where A, my lord, read in the nature of mandamus by commanding and directing the respondents, and in particular the respondent number 1, to appoint an arbitrator in terms of section 11 to determine the amount of compensation to be awarded to the petitioners for the period commencing from midnight of 31st March 92 to 23, to say when the date when the requisition property was physically and actually delivered to the petitioners within such a time bound period to the. So, my lord, my humble submission, the land acquisition officer, my lord, here has made a determination already. He is not happy with that. In that situation, my lord, I shall show, my lord, section 11, my lord, is not available. Section 11 is available, my lord, where parties have not agreed and then you have not received any compensation, or if there is a part compensation, you deposit it and then you appoint an arbitrator for determination what it should be done.
Yes. Please show me the provisions.
Yes. Finally, my lord, see section 11.
Yes.
Where any premises are requisitioned under this act, there shall be paid to all persons interested compensation, the amount of which shall be determined in the manner and in accordance with the principles hereinafter set out. Namely, where the amount of compensation can be fixed by agreement, it shall be paid in accordance with
This
such.
is not as per a agreement, does not say anything.
No, this has been as per the court's order, Justice Tandon's order.
No. So there is no, we are coming to this
Yes.
section.
Yes.
So A does not apply.
It does not apply. Next.
Yes. Then
Where no such agreement has been reached, the state government shall appoint a district judge or an additional district judge as an arbitrator. This is also, my lord, not applicable here. Why?
why?
Because I'll show subsequently. Because here, my lord, we are not at the stage of determination, my lord, of any compensation by. Kindly, my lord, see. I'll show the first order.
Yes.
Justice Tandon. Kindly, my lord, take this. My learned friend has not shown that.
How have you determined the amount of compensation? Please show me that basis.
Yes.
On the basis, not on an agreement.
Not on the basis of an.
So how have you determined that? So there are two things. If there's an agreement, there's an agreed formula.
Yes.
Nobody can depart from that.
Yes.
If there is no agreement, there has to be a body who will adjudicate that.
Yes, but here
So
I bow down.
which body will adjudicate that?
I bow down. But assuming, my lord, this stage was not used and a certain amount was given to him, whether that amount is fair or not will be determined by 14.
Why?
Because this process, my lord, was eliminated.
Yes, please kindly come to 14.
Yes. Then, my lord, may I read the rest also so
Yes,
that
yes.
we get the.
Yes, you can complete this. Yes.
Yes. See, the state government may in any particular case nominate a person having expert knowledge as to the nature of the premises requisite to assist the arbitrator.
So this is in aid of B.
Aid of B. Then, my lord, again D is at the commencement of the proceeding before the arbitrator, the state government and the person shall state with the respective opinion. Arbitrator shall be determining the amount of compensation.
So how the arbitrator will determine is the next.
How it is to be done. Yes. Provided that, notwithstanding anything contained in 12, in case of the entire premises which was constructed after the commencement of this act, the amount payable annually.
So this is
the
with regard to the
formula.
yes.
This is the formula.
Yes, yes.
So the formula is available.
Yes.
There is who will do it? One arbitrator, two the authorities can do it themselves by applying this. Kindly see, my lord, this is the formula.
It's arbitrator shall in determining. It's not any person. Arbitrator shall follow this while determining. It's not any other person.
Notwithstanding anything contained in 12, my lord, we will 12 is
Proviso is to clause E.
collect and subject to correction. Kindly see 12.1. Matters to be considered in fixing compensation by agreement. This was in the process of agreement only it was happening. The court had said.
Show me the agreement, agree formula, nothing remains there. Where is the agreement? It was requisition. Where is the agreement?
My lord, kindly, my lord, the collector was asked to. I'll show that order. I'll come to that.
Collector was asked to by whom?
By the court. By the court. Kindly see
No,
this order.
but Justice Tandon directed appointment of an arbitrator.
No.
Justice Tandon said that initially till 89 arbiter was appointed. Now the collector is to determine.
Yes.
Yes.
So I said that the determination by the collector was not as per my whatever I had sought for in terms of my letter dated 11th of October. The amount that the collector had determined, was not to my liking. So I have taken that under protest, and that is clear. So the point today is, my lord, that this amount which has been determined, no, there's no agreement between the parties, no consensus ad item between the parties with regard to the quantum. So I'm entitled to ask for appointment of arbitrator to set the quantum.
No, there is one.
If Mr. Bordon, if the collector was directed, then this may not be the procedure. Where the paragraph is supposed to the apportionment, the collector shall keep the amount in revenue disposal till there has been a settlement.
Yes.
Yes, you are in section 14.
Yes.
Please kindly come to section 14.
You know, all I'm saying first is that today he has a compensation. We are not a stage where it is to be determined. The order was there, collector should do it. Now, if he is unhappy with the collector's determination, whether an arbitrator will not can
So, what is the procedure contemplated? Please show me that procedure.
kindly see, my lord. 14.
14.
14A. Particularly 14A3 also I'll show. That's 14A3. Let's go straight to that. 14 capital A, section 3, subsection A. Rent or compensation may be revised only if there has been an increase or decrease in the market value of the
Please start from 14.
Yes. When a dispute arises as to the person or persons to whom the amount of compensation or any part thereof is payable, or as to the apportionment of the same or any part thereof, the collector shall keep the amount in a revenue deposit till there has been a settlement.
What does it mean?
It means that the collector only then, my lord, is the authority to
Who?
keep the disputed amount aside, which he has to
That's
do.
a different thing altogether. He cannot decide the dispute as in 18. 18 reference is not section 14. So if somebody comes and says no, A is not entitled to the amount, I am entitled, B is entitled to the amount. So such a dispute only then, if that is
Also apportionment.
yes, anything. He may say yes, A cannot get 50%, he is entitled to 25%, I am entitled to 75%.
Yes.
So if such a dispute is raised, then the collector's duty is to deposit till settlement. That's only contemplated under 14. Nothing more than that.
No, I would read it, my lord, to say that
Please show me how you read it.
when
It does not say he can dispute this dispute.
he can dispute the amount. He's today disputing the amount.
He's disputing the amount. Show me section 14.
14A. What is
Yes, 14A. Can you come to 14A?
the amount?
So 14 does not say anything with regard. 14 gives the empowers the collector to put it in a deposit till settlement, to keep it in a deposit till settlement of the dispute is reached.
Yes.
Nothing more than that. Now let us come to 14 capital.
But then the power of the collector to determine is there in 12.
Show me 12.
Matters to be considered in fixing compensation by agreement. So now whatever will happen will be by agreement only, my lord. In determining the amount.
Determining the amount of compensation which may be fixed by agreement.
Correct. So
where is the agreement?
Today, my lord, it has to be that we are now, my lord, going towards an agreement. We will propose something. He will have to agree. He will have to.
He will have to agree.
No, or disagree.
So it is fixed by agreement. What did you say? That follows from 11. If there is an agreement, yes. If there is no agreement, if Mr. Bordon agrees to what you propose, I think I will be the happiest person. I will be the happiest person.
Now, kindly see 14A1. A. The rent compensation of any premises shall be liable to be increased or decreased where the rent compensation includes the tenant's share, etc., etc., by deducting the rent or increase where the landlord incurs expenditure, etc. The collector shall, subsection 2, on an application made to him by the landlord in the prescribed manner, fix in respect of any premises the increase or decrease referred to.
If
To
there is,
involves that.
if there is a rental amount fixed, the landlord wants to know it is to be increased, then 14A comes.
So today, my lord,
It's not this case. Now you have vacated. There has been a amount he is claiming. You are also not agreeing to that. So there cannot be any agreement. He is giving one figure, you have determined another figure. So there cannot be any agreement.
if there was not subject to
There
correction,
cannot be any agreement.
No
So there is a
agreement.
dispute. If there is a dispute, it is to be decided. Decision is by arbitrator 11.
once appreciates, my lord. 2018, my lord, the collector, my lord, makes this decision and gives him. If he did not dispute, then he taken the money.
Under protest.
My lord, subject to
Why
there
did
is
you pay that? You may say no. Till it is settled, I will not pay it to you.
but
It's under protest. He has given an objection to
my
that.
lord, he has taken.
Usually, at times, when there is the admitted amount, this is not the disputed amount. Admitted amount, you are liable to pay. At times, when it comes, there is a dispute. So we pass an order, yes, let the admitted amount be paid. See, admitted by you.
But then he
But
has-
that does not take away his right to challenge that.
Then I have a decision. I'll show. It's just that, my lord, I had marked some paragraphs, but I
That
have
will
to
help
read
me.
the whole thing.
Is the marking is against you or in no,
Right?
markings are in your favor or against you?
I that no.
Show me.
There one more thing I want to say. If he had disputed this, he should have put in the money and then come here. He cannot enjoy the money on one hand. And from 18, kindly mute all these letters. He's enjoying the money.
Madam, what you are saying is he is enjoying. That is admitted by you. You are not saying that he is not entitled to that. Let us suppose he is claiming 100. You are paying rupees 10.
Yes.
So when you are paying rupees 10, you will be saying, yes, you are enjoying 10. Why are you interested in 90? That cannot be a stand. That cannot be your stand. After all, you have utilized the property.
And I've given.
You have given, may not be at, please decide that. Let the arbitrator decide. No, his claim, reject his claim. End of the matter. Let his claim be rejected. Let the arbitrator opine. No, what has been determined by you is correct. End of the matter.
One more.
If he has other remedies, he will pursue or he will have to accept that. But that cannot be a ground by saying no, that will not be adjudicated. Since something he has received, he is stopped from challenging. What are you saying?
Saying that he can't be
So who will decide that? Who will decide that?
Whether he
The question is how it is to be decided and which authority shall decide. That's the simple question which is being raised in this petition.
and by asking that arbitrator should be appointed in
Yes,
terms of
yes. For that decision,
your kindly will not see this.
arbitrator is nothing to decide that. What's the difficulty? What's the difficulty you have?
As an officer of the court, I would say, in a situation like this, where the state has compensated him, by giving a proper formula. It is not like we have given him an arbitrary amount. I have disclosed, how the compensation.
Let an independent person say that yes, it's correct. He is not entitled to that. Let an adjudication be done. At times, madam, there are always provisions in land acquisition matters. You are doing these matters. Land acquisition matters, awards are passed.
It is passed.
So
But
a person may be aggrieved by that. So that award has been passed by a competent authority under the Land Acquisition Act. They are following some principles. The procedures laid down under the Land Acquisition Act or the Fair Compensation Act, whatever it might be. Then also, there is a provision under this statute. If a person is not satisfied with the sufficiency or the adequacy of the compensation, let us keep aside apportionment part now. A similar case, if a person says no, you have awarded 100 rupees, I am entitled to 500 rupees. Is he not entitled to challenge that?
Same person, not by an arbitrator. It will go back to.
Madam, what's the provision of section 18? of the Land Acquisition Act, not this act.
We are under this.
No, I'm asking. I'm giving you an example of Land Acquisition Act.
No.
No, I'm giving you an example of Land Acquisition Act. That's not by the same authority. Collector, who is deciding that he has to refer it to the court for a decision.
Otherwise, he'll be a
You
judge.
cannot be, yes, you cannot decide on your own that your determination, you will never say that your determination is wrong.
But arbitrator cannot perhaps consider.
Show me who will decide. Show me under the statute who will decide.
But there is no provision only. He
Yes,
has to
yes,
accept
11,
it.
11 he has shown a provision. How do you come out of this?
This I can come out because this is the stage where he has not received any money.
No. This does not say. No.
You can't take the.
Please show me. Shall be paid to all persons interested in the manner and in accordance with the principles laid down. Where the amount of compensation is fixed by the agreement shall be paid. Where there is no agreement, appoint as an arbitrator. Arbitrator will decide that.
Here, Milord kindly sees the order of justice standard, Milord once. He has not shown page 23. The order starts what it says.
He showed page 33, you showed 23.
Yes, 23 starts. I am showing Milord 34.
Yes.
That was the page Manu was reading.
Page 34, Milord.
So this order was passed in this writ petition.
Earlier petition.
Earlier writ petition.
Now can you see?
What was the pair in the earlier writ petition?
Earlier petition was to restoration of possession.
He did not ask for an arbitrator.
I could not have. Because till then,
Restoration of possession and
I just have to.
He has not asked.
No, why should I?
That is my point. This might kindly appreciate this.
I cannot ask for arbitrator.
Huh?
Cannot be. Cannot be. Cannot be. Order to rule 2 will not apply. For a simple reason, the cause of action was not there.
yes.
That
Yes,
is my
yes.
point. Do you lordship has got it? Kindly see 30.
I've not got it. I've not got anything.
I had called for the records. I wanted to see the earlier petition and I remember, Milord, it's coming after a long time that there was no.
Yes, page 34, yes.
Yes, 34, Milord. Kindly see the second last paragraph.
Yes.
It is brought to the notice of this court that an arbitrator was appointed. This appointment was in 2007 by this court for ascertainment of the compensation required to be paid to the petitioners for requisition of such premises, and the said compensation was determined. The language is determined as far back as 1989, and since thereafter, no revision has been made. My attention is drawn to section 11, and in such event, agreement if it is not reached, the state government is empowered. There is no decision or direction that you must do it. He has considered that this provision is available. This court, therefore, directs the state government to take steps relating to the revision of the compensation for the period from the midnight of 31st March 92 till the property is acquired. Or
Show me the revisions made from time to time. End of the matter.
Yes.
Show me the revisions made from time to time.
Yes.
আমার কাম তো করিনি।
Now, I will.
At what intervals you have revised this rental compensation?
Yes, I have everything.
Show me. Where you have annexed?
I have done all that.
Where have you annexed? Opposition you have filed.
Okay.
Opposition.
Okay. Here only contempt when you filed. We filed an affidavit in that contempt, which is at page 41.
No, you have not filed any affidavit in this writ petition.
They were given opportunity, they did not. There's one order recording that they choose not to file an opposition to supplementary affidavit. Kindly have a look.
So the supplementary.
So the supplementary affidavit is
No, in the main writ petition you have filed an affidavit of opposition.
In this?
no.
Yes.
I think everything was on record, which is why perhaps we did not.
That was the main writ petition affidavit filed for it.
Since the point of the question of this doesn't come into your question of law.
No, there are two aspects of the board. If there is a revision, now revision if you come,
Kindly,
I've understood what's falling from. Right? Well, revision would only arise post the determination. Revision is post determination. Now, the reason I placed those orders in my supplementary affidavit, kindly see what exactly was meant. Kindly see page 8. And I've placed series of orders.
Page 8 of
the supplementary affidavit.
yes.
What is now being posted as revision is basic determination. Kindly see page 9. It is indicated in the said affidavit in opposition that pursuant to the order and judgment dated 10/8/18, the rent compensation has been determined, which is annexed to the instant affidavit of opposition. It is pointed out that the said rent compensation has been determined till the month of March. In fact, the possession was returned to the petitioners by the KMC on 13/1. Then look at the next paragraph. In view of the above, the respondent number 1 is directed to take further steps for determination of rent compensation. If that be not all, kindly please. Page 12. Subsequent order dated 31st of March 2023. But at that relevant point of time, what they were proposing is to wriggle out of the contours of this the content application. And they, kindly see page 13. Mr. Thor, learned advocate, my learned friend not appearing in the matter. Mr. Thor, learned advocate appearing for the collector submits that in terms of the order, the compensation was determined and adjudicated upon. This was duly communicated to the added contender for further follow-up action. Mr. Ghosh is very much vocal in submission that delay cannot be attributed to conduct of the authorities as determination of compensation was initially communicated. So the entire thing is determination.
Which is done by me and I'm disclosing the opposition.
Kindly see. Therefore, the contention is refuted by learned advocate appealing to the collector. According to him, the quantum of rent compensation was communicated after determination, and there was no further modification or clarification bearing amount so determined by the collector. Then, kindly sees the next order at page 18, at page 15, order dated 18th of April. Third paragraph, at the very outset, Mr. Ghosh, learned counsel appearing for the alleged contender, tenders unconditional apology for the delay occasioned in disbursement of the amount by way of rent compensation as determined by the collector. So, these amounts which they have paid is in terms of determination.
Sir, I have the earlier writ petition with me and I'll show the prayer now.
No, please show me the revision from time to time. How it was
Yes,
revised.
that's true. So that.
Yes, please show me the revision.
Just show the
Please show me the revision. I will come to the prayers.
And one,
Show me the
one more. Page 68. Page 68. Kindly takes up page 69 for once.
Yes,
Just this
yes.
standard order when it disposes of contempt application. Kindly see.
69, yes.
69. The second last paragraph, the last 4 lines. Whether the quantum of compensation is fair or justified cannot be gone into in exercise of contempt jurisdiction. The moment the court finds that the order has been complied with, it is open to the petitioners to take appropriate steps in personal law. So the entire facts was before the court. And most importantly, I showed my protest was prior in time to the payment. So these are all determination. The question of revision would only come where there's already a determination made and then there are changes.
Yes.
So, and this has been my stance right through. And in fact, I've shown that at the time when they proposed to pay me, I write to them that this is something which I accept in protest. That's on 31st of March. On 4th of April, after noting my protest, they pay me the amount.
Yes, that you have to say. Yes, yes, Ben.
Lord. Fine. So, in the earlier repetition.
Please show me the revisions from time to time. How have we revised the compensation? What was the initial compensation? How it was revised from time to time, starting from 1992.
Yes, Lord, kindly take my affidavit, page 47 of the writ petition, which is referred to in all these subjects.
Affidavit. You have not filed any affidavit to the writ petition.
Petition, it is annexed.
So, this writ petition, yes, page 47.
Yes.
Yes. Yes.
First, before that, kindly take the letter at page 36. This is not the petitioner's letter of 11th October 2018, page 36. Kindly see below what my learned friend last page. His lordship, last paragraph of 36. His lordship was further pleased to direct the state government to take steps relating to the revision of the compensation payable to the undersigned for the period 92 thought to be acquired, could be acquired, or in the event no acquisition proceeding initiated in the manner and within the time indicated, the same to be physically added to. So he is also saying revision. Now, my lord, he says, next page, third paragraph, it would be pertinent to mention that the district judge had entered into reference to adjudicate the dispute with regard to the rate of rent compensation being paid by your good office and passed an award on 2007, whereby Miranda, the learned arbitrator, was pleased to internally uphold that your good office would be liable to pay rupees 15 per square feet per month in respect of the requisition portions of the said premises for the period prior to 89. Due consideration was given to the situs of the aforementioned premises and the amenities available. Learned arbitrator, however, was pleased not to grant any relief for the period subsequent 89. Copy of the award is enclosed. A perusal of the above award would show that the rate of 15 was fixed at such date for the period 80 to 89. Thus, 15 per month became effective since 1980. The inflation rate in India between 1980 to 92 was 196%, which presupposes that rupees 100 in 1980 would be equivalent to rupees 296 in 92. Thus, rupees 15 in 1980 would be 44 rupees in 94. And then he gives the calculation for each period, Milord, as per revision. So, what he is today asking, Milord, is revision, Milord, on the basis of inflation. The undersigned submits that if such mode of calculation is adopted, the undersigned would be entitled to a revised compensation in the following manner. He does not, Milord, ask for any appointment of arbitrator for this adjudication in 2018. He says it should be at the rate of 44 till 2097, at the rate of 69 till 2002, at the rate of 92 till 2007, and so on and so forth, Milord. He says, in such, next page 38, in such scenario, assuming the enhancement would be at the rate of rupees 10 per square feet per every month, 5 years, compensation is liable to be revised in the following manner. However, such eligibility would be on the basis of super built up area, the claim of the undersigned. He says all that. Then he says about market valuation, page 39, which I showed below, section 14. Market valuation of an area such and such square feet, the value would be, according to him, 173. Undersigned reserves their right to produce further documents. So, he has today, Milord, the letter is addressed to the land acquisition collector. There is, Milord, no request that you appoint an arbitrator in terms of 11B. He submitted to my jurisdiction and he's saying that you revise. This is what I want. Now, Milord, what I do is, again, Milord, there is a letter on 2019, which is at page 40. He's here, Milord, again to the land acquisition officer. In terms of the solemn order dated 10th August 2018, passed in the aforementioned matter, there was a direction upon the state government to take steps relating to the revision of compensation for the period commencing from the midnight of 31st March 1992 till the property in question would be acquired, etc. Pursuant to the order, hearing was called on 12th October 2018 at the office of your good sir, which was duly attended. Again, Milord, he submits to my jurisdiction. However, we are yet to hear anything on the subject thereof from you. Now, Milord, somehow, Milord, we were internally assessing, but we did not get back. He files a contempt. There, Milord, I file my opposition and I have disclosed what I have done. Kindly see, Milord, page 41. This is, Milord, my opposition, and where I have given the calculation to answer your lordship's query. Page 44, paragraph 3. Has your lordship not got that? Yes. For now, in compliance of the direction, I am submitting the following fact. Pursuant to the order dated 10th August 2018, passed by the High Court, the first land acquisition collector calculated rent compensation of the said premises up to 31st January 2019 and sent the estimate to the Land and Land Reforms and Refugee Relief, etc. for authentication and vetting. We did this office memo of Calcutta. Copy of the letter is annexed. This was annexed. The Land and Land Reforms and Refugee Relief Department, we did memo dated such informed the Commissioner and the Land Acquisition Collector of the vetted and authenticated amount of rent compensation. This was also annexed. On detection of certain errors in the calculation of rent compensation, the previous estimate was modified, and the same was again sent for vetting and authentication of the land department with its memo dated such and such. This time, the calculation was made up to 31st March 2019. A copy of the said letter is annexed herewith and marked with such and such, and the department with its office memo dated 2019 vetted and authenticated the rent compensation, which comes to 2 crore 96. A copy of the letter is annexed. The land department addressed this memo to the Commissioner KMC with a copy to the land acquisition collector. In subsequent correspondence with KMC, the land acquisition collector also mentioned this amount of 296 to the department. Now, Milord, page 46, para D. At the time of hearing on 3rd February 2023, when the Honorable High Court Calcutta asked the KMC to release the rent compensation as determined by the respondent number 1 till March 2019 to the petitioner. This is the order, Milord. There also the court also accepted and said you release. The KMC did not object to the amount as determined by the first land acquisition collector and vetted and authenticated that. In the order of 3rd February 2023, this Honorable High Court also directed the collector to take further steps for determination of the rent compensation on and from month of 19 till 23 within 2 weeks from the date. In pursuance of that order, the land acquisition collector calculated an amount of rupees 76 lakh only for the said period and send the estimate within his office memo of 7th February 2023 for authentication and vetting. Copy of the memo is annexed. Then the land department on 23rd February vetted and authenticated the amount of 76 lakh. Then below page 47, paragraph G. F also, first land acquisition collector communicated to the commissioner requesting him to take further steps, and then 2 crore 96, the check was deposited on 29th March 2023. The confirmation of the credit of the amount to the PL was to be received on such and such. The Honorable Court was informed about the credit of the amount to the advocate. The rent compensation received.
How the compensation was assessed?
So these are all part of the memos which I
Give me the calculation how it was assessed.
yes, that then I'll have to Milord file an affidavit.
What is page 57?
Yes, so this is the memo.
I can assist you this then.
Okay. Yes. Yes.
Yes.
And this is also for
So this is the basis of your enhancement.
yes, kindly please.
This is under what provision? How have you, what principle have you applied for enhancing this amount?
There are guidelines which refers
Where are those?
that I have to bring. I'm
Mr.
satisfied.
Banerjee, where is, Mr. Borden, where is the information in this calculation?
I cannot be rendered revenue.
Mr. Borden, only one thing. They have assessed the compensation at a particular rate. If the energy takes time to take instructions, what's the basis? It says there are some guidelines or factors which exactly that. Now, perhaps page 57 is the calculation, subject to correction by you, on the basis of which you have been paid.
Yes.
On the basis of which you have been paid. So, what is the infirmity in this calculation? Let me understand the point of dispute.
The point of dispute is
Or the other way around is you want an appointment of an arbitrator to decide the rental compensation. So the arbitrator has to apply certain tests or certain formula. What is the basis of that? Please show me that. How this is to be enhanced. Whether the statute provides for that.
I'll just
kindly see 11. The nuances would come from D onwards. 11D.
When the
At the commencement of proceedings before the arbitrator, state government person should be compensated shall
state
state
what the respective opinions, yes, that's another thing.
that
What is the procedure?
Yes,
What is the procedure? How it is to be?
the arbitrator shall in determining the amount of compensation to be awarded to landlord have regard to matters referred to in A, B, and C. Provide some kindly sees thereafter. Provided that notwithstanding anything contained in section 12. So this will be proviso.
Yes.
Then in other cases, amounts payable shall not exceed. Then there are two parameters. Now comes to 12. So 12 has also got to be taken into account by the arbitrator when he decides the compensation.
Yes. Now there are two aspects. One is with regard to an appointment of an arbitrator. Second, please show me prima facie where how this compensation according to you or why this compensation according to you is wrong as per the provisions of the statute.
No.
Second is, Mr. Bordon, I give you a hypothetical example. A property is requisition. Now there is a dispute, there is no agreement as to what would be the rental compensation. Let us suppose it was requisition sometimes in the year 1950. Let us assume that it's continuing till date. Now, there was a dispute or there was no agreement, if I can put it, for fixing of the rental agreement. Now, an arbitrator has been appointed. He calculates, fixes the compensation. In the year 1950 itself, let us assume. He says, yes, for these 5 years or certain things, this will be the rental compensation. Now, after 5 years or after 10 years, whatever it might be, again a dispute arose as to what would be the compensation. How it is to be increased. Because according to you, who are the landlord, you will be saying, yes, in the meantime, price index, inflation and other things. So 5,000 will become 50,000. That might be your basis. They will say, no, 5,000, 5% increase, such as that it comes. Now again an arbitrator will be appointed for that. Now again, let us assume, second time an arbitrator is appointed. He fixes an amount for the next 5 years. Again after 5 years, you come up and say, no, it will be now 5 lakhs. Again appoint an arbitrator. Because they will be saying, no, it will become 7,500. So again an arbitrator will be appointed. He will fix the compensation for next 5 years. Again a dispute whether it will continue or their help will be an initial assessment by the arbitrator where there is no enhancement. Thereafter, other provisions of revision will be made. What does the act say?
I bow down. So kindly for once, take 11E, subclause 2.
Yes.
What is the mode in which it is determined? Kindly sees.
Yes.
In other cases, the amount payable shall not exceed. Then kindly sees 2. Where the premises were not so let out, such rent as would be reasonable, having regard to the situation, locality, and condition of the premises.
So these are the yes. I'm not on that. Perhaps I could not make you clear. Parameters, yes. Let us consider
So these
the
are
arbitrator, upon considering these parameters, has fixed a figure in 1950. In 1950.
I bow down.
Now in 1955, again arbitrator will be appointed.
To that, my assumption is in this matter, till 89 an arbitrator was appointed. So when an arbitrator was appointed, it definitely mandated that there was dispute between the parties so far the quantum was concerned. And
no, arbitrator was appointed how many times in this matter? Once.
But that was for the year prior to 89.
I appreciate that. So it was so let us now come to the facts of this. So prior to 89, let us suppose in 85 or 1980, whatever it might be, an arbitrator was appointed. So for fixing up to 89, that was fixed. Now, again a dispute occurs what should be the quantum from 1990. Again an arbitrator,
The reason-
or there has to be a different.
The reason I'll say, why this problem arises out here, why this date of 89 and 92 comes into effect. 89 comes into effect because as on 89, they float a notification under section 4 of the Land Acquisition Act.
No, that is, I'm not of that. Please, let us simplify those procedures. Let us not take into those acquisition proceedings. 89 till 89, arbitrator was appointed, fixed as an amount. Now, it was operational till 1989, December 18. So from 1990, let us assume,
In fact,
again a dispute.
no, Mulad, not 99. In fact, Mulad, I have rather foregone this period from 1989 to 1992.
Let us forget about that. So I am asking you, let us take a hypothetical case. So what would be, again an arbitrator has to be appointed, or there is a procedure prescribed under the statute for revision, because there might be an initial fixation, thereafter revision, or all time fixation. What's the law?
Mulad, my understanding is this, Mulad. Justice Tandon's order said that the first land acquisition collector should determine the compensation post 89. In fact, all the subsequent orders, my learned friend is reading that one word revision. In fact, all subsequent orders say determination, and in fact, it has the consistent stance of the learned advocate representing by the client of my learned friend now before the court of contempt, that this determination was a new determination in terms of the order passed by a standard. So that determination of the rent
Mr. Bodhol, revision is also determination. Revision is in effect also a determination, because let us not go to those loose terms.
If that be
Because
similar,
if the revision was given effect to, it's a determination for that period.
true,
So let us not go to the dictionary meaning of the difference between revision and determination.
I will not. But
So
if that be similar, now this from 89, this is the first determination. If now an arbitrator is appointed and the quantum is fixed, the question of revision would only come thereafter after X number of years. Now, in this case, it will not come because the property has already been vacated. The question
no, I'm not on this. Let us think it's continuing. So each and every time arbitrator,
No.
or once an arbitrator fixing, thereafter revision as per the statute.
as per statute.
So show me these provisions regarding revision as per the statute.
Mulad, the provisions.
So let us now come to a hypothetical case. There was an initial determination, continuing, then revision. What would be the statutory provisions applicable for that?
Mulad, would kindly see 14A.
14A, yes.
Mulad, even that does not take into consideration. Even that does not take into consideration the question of revision, because what it says is increased or decreased.
Yes, that's revision. Increase or decrease is after determination.
I bow down.
After a determination.
I bow down.
So now that's my question to you is whether determination by the arbitrator will be at all stages or at first stage,
At the first stage.
then increase or reduction, whatever it might be, that will follow 14 capital.
Yes, that will follow.
Now, my second question to you, let us now come, yes, X amount was determined initially by an arbitrator. Now, after a passage of time, there is a revision, X plus 10. Now you are agreed by that. You are saying, no, it should not be X plus 10, it should be X plus 20.
Yes.
Now, what is the provision under the statute against that revision order? Please show me this.
If the statute is silent, if the statute is silent, I have the writ court to approach. Because I cannot.
No, I'm asking you whether the statute provides for that. Let us proceed step by step.
That view of the matter, Mulad, if Mulad says that the terminology, determination, and revision would not be read at Euclid's theorems, Mulad, then I say, Mulad, again, once the revision is done, I'm again entitled to come back and take recourse to section 11.
because there's no agreement.
That's a way of argument. I'm asking you, let us
No, it's
assume
not
that-
there. So
so there is no provision to challenge that order of revision.
in the statute,
Yes, so if there is no statutory remedy, you can challenge
there is
by way of a writ. That's a different thing altogether. That's and even the writ code has to go by some formula.
now, Muller, now what happens
Now,
is
what should be formula?
now
Whether this formula of revision as under 14 capital A was correctly applied or not. That's the only test which the writ code can apply, nothing more than that.
Therefore, my lord, when 11 prescribes, my lord, we see it quite regularly. When there's a question of compensation, the code on many occasions my lord, delegates it to the authority. Here, my lord, the delegation is prescribed in the statute itself. If my lord feels the district judge is not the proper person, appoint X. But I want.
No, what's troubling me, Mr. Bodhuni, whether the statute contemplates appointment of arbitrator and relegating the matter to the arbitrator at regular intervals, or it contemplates appointment of an arbitrator for the initial determination. Subsequent revisions will follow in line as per section 14 capital A.
Now,
That's my query to you. Please answer me in that line.
my understanding of the law is, my lord, there first has to be a determination by the collector insofar as quantum of compensation is concerned. Has to be determination. Now, my lord, if thereafter there's any increase or decrease, I can go.
Show me the first determination by the collector, which statute, which provision states that. Initial determination by the collector, please show me.
That's prior to 89. Prior to 89, no, subsequent 89.
The statute, how it is to be initial determination by the collector, please show me that.
Provisions regarding compensation comes from 11.
So 11 says, start from agreement, no agreement.
Yes.
Here the collector does not come.
True.
Is either agreement, so the parties it may be an authority who is requisitioning, he may approach, you can come, both of you can say, yes, I want this, you want that, there's an agreement. So yes, the agreement is 5,000, increase 5% every 5 years, 10 years, so that's the agreement, it will follow, nothing. Now, it was requisition without any agreement. Then 11. It's the first determination.
Initial requisition at the time of, in fact, I'll say, the initial requisition was in 3 phases 65, 77, 80. But at the time requisition was done, we were being paid something around paltry 1.70 or 2.50 per square feet. Thereafter, my lord, applications were made before this court in terms whereof the arbitrator was appointed. In terms of which the arbitrator was appointed, and the arbitrator was appointed for the period till 1989.
That's the statute. Because Mr. Bordon, a reading of the statute says so. So initially, if there was an agreement, here in your case, there was no agreement. So when there was no agreement, they offered you something. According to you, it's a paltry amount. So you disputed that. Then 11B comes into play. Now 11B, in respect of a property, for a specific period, there has been an adjudication. Let us not use the term determination. Adjudication by the arbitrator.
Yes, for the period till 89.
Yes, for the period till 89. So now, after 89, once there is an adjudication, there has to be a revision or a fresh adjudication.
There has to be a fresh adjudication.
Show me the provisions. Again, a fresh adjudication is called for under the statute.
The reason behind this is, any revision would be subsequent to a determination. There must be a determination, revision or modification will be subsequent there. In our case,
do you have an authority in your support of this argument? This from time to time, each time arbitrator will be appointed for determination.
It's not there. To be frank, it's not there. So the issue today is this determination that was initial.
So that's the sum and substance of your argument.
Yes.
According to you,
an
arbitrator is to be appointed for determining, and Ms. Banerjee.
for adjudicating whether the determination is correct or not. So, Mullah,
Where is that provision?
Well,
Where is Mr. Orkut? 11B is at the initial stage. It does not say if there is a dispute with regard to the determination. It does not say 11B comes into play where there is no agreement.
yes,
So here there was no agreement.
Mullah,
Initially, an adjudication by the arbitrator was there. Now, according to you, where does it say after revision, then arbitrator? Where is that?
Mullah, and it is bigger one. B.
Yes,
It
11B.
says, 11. It says where no agreement can be reached. So, Mullah, the amount which is, Mullah, determined by the collector. If I'm aggrieved by it, Mullah, then I say that there no agreement can be reached. What? No such agreement. That no such the qualifies, Mullah, amount of compensation. So where no agreement between the parties can be reached, where this compensation amount, then the state government should appoint the district district judge.
That was my query, first query. That this statute, according to you, 11B contemplates appointment of arbitrator after every 5 years.
If parties do not reach an agreement,
they will not reach. None of the cases it will reach. So the statute, according to you, contemplates there will not be. I think 5% of cases there will not be any agreement.
Otherwise,
so this act contemplates appointment of arbitrator every 5 years when a revision is necessitated.
May I put it this way? So, can this be the law that once a determination, it goes to the arbitrator, and then I am left at the whims and fancies of the mercy of the collector when he revises. So he might revise it in a manner which is not commensurate with that. I cannot render remittless. I must have a court to go.
There are two aspects.
Either I say
there are two aspects. 11 is the initial determination. Initial determination. Then, when there is an initial determination, there may be cases of revision. Revision may be either way.
Yes.
Let us assume 5 flats of yours were requisitioned at X price. They choose to give up possession of 2 retained sheep. So, revision may be either way. So, they may require something more, or this price escalation clause, for that it may enact. So revision may be either way for very many reasons. So my question, that's the thing, whether this act, that's only to be interpreted, whether this act contemplates appointment of arbitrator at each stage of disagreement, or initial dispute will be resolved. Thereafter, the statutory modes for revision will apply. That's only to be.
The first query, my answer would be that here, the initial determination was till 89. So now, the determination which they have done is a determination which, if I'm agreed by, I can fall back upon 11B. But the very simple reason, the quantum of compensation determined earlier was till 89. Subsequent to 89, there has to be determination. And that is the way they have determined. In fact, Malak has seen Malak 57.
Because Mr. Borden, what is probably if you take up the National Highways Act. Most of this act, there is separate provision. So PG also amount of determination of the compensation, competent authority. So if a person is agreed, then arbitrator. So that also says appointment of arbitrator against determination made by the competent authority. Subject to correction by you, this act does not provide for an arbitration at the instance of a person being aggrieved with the determination made by the competent authority. Please show me that provision, because unlike National Highways Act, unlike Land Acquisition Act Section 18, this provision is a different thing altogether. Because the scope is a different thing. Initial determination, thereafter revision. It will produce the same act. Bengal Premises Sales Act, it also says for fixation of fair rent. Then revision statute provides
20.
how it is to be done. 18, division of
And
fair
then
rent,
20.
how it is to be done. So initial determination by an authority, then statute provides for
Yes.
revision.
Yes. So that the statute contemplates.
Here also statute contemplates. Initial determination either by way of agreement or by way of an appointment of an
Now,
arbitrator, then revision by the statute as per the statute.
if that is the thing, then it's for the state to now show that the document which appears at page 57, they were also proceeding that this was an exercise of revision and not a question of determination.
Yes.
So they have to show this. Now kindly seize their stance right through. Kindly seize. Look,
Yeah, I will produce my whole records. It's a 3,500 square feet, 3 floors in Gaston Place, old building. He's already got 4 crores. If this is
it's
not
not an old
extortion, then
building.
what?
It's Gaston Place is not an old building. It's not
Yes,
renovated.
57.
Kindly seize.
Madam, I'm not concerned with the quantum or the area, what I will do. I only have to consider whether the provisions of the statute has been followed or not.
Yes, I'll show, my lord. I have revised according to the statute and I'm paid him.
Kindly seize, my lord.
According to you, the quantum may be sufficient. Mr. Bordon says it's a paltry amount. Of 4 crores is a paltry amount. That's according to Mr. Bordon.
Because they say, my lord, calculation of rent compensation in respect of premises number such and such as per order dated 3/2/2023.
That's Justice Stannon's order.
Yes, 3/2/2023. The
Yes.
kindly seize. Order
I've
dated.
seen that. I've noted what was.
Yes.
According to you, it's a determination.
Yes.
I follow that.
So if that is a determination, my lord, this determination will, since this determination will affect 11B, subsequent to the determination had
So this determination cannot be 11 because he's not an arbitrator.
no.
So this is not a determination under 11B.
No.
So under what provision this was determined? Please show me that provision.
My lord, I say this was determined in terms of the order passed by Honorable High Court.
Under what? No, under what provision?
It has to be determination, my lord.
Under what provision of the statute? The authority has to act as per the statute.
Just give me a moment. Compensation is, my lord, it's basically chapter 3. There's nothing beyond that. It's chapter 3.
Chapter 3, two links. One is the initial determination on agreement, on dispute.
But so if this statute has to be made workable, can this be the law? That if I'm agreed by the revision, I have no court to go to.
It's not that you have no court to go. It's the statute. The Bordon, this is well studied. Here is a statutory remedy. You have to avail that. The court is there. So it's not that you are remediless.
No, it's not. This is precisely the point, bro.
Then after all, that is why I asked you that question. If you have to approach the writ court, being agreed by the determination, if this is accepted, that yes, no, it's not necessary, or the 11B will not apply. If that is accepted, this manager's argument is accepted, that 11B will not be applicable, you cannot be rendered remediless. So now, there is no remedy as per the statute according to this manager. If that is accepted, you can approach the writ court. Now, if you challenge that compensation amount before the writ court, so the writ court has to consider whether this revision was made as per the statute or not. Please do a homework as to why do you say this is not as per the statute. I give you a time. Please see, because there are two ways of looking at it. Even then, you will be saying, yes, if I do not have a forum of arbitration, I can approach the writ court. So, even then, you can make a calculation what the statute says with regard to the revision. Where is the infirmity? if that is the infirmity, that authority can also be directed. You can make a calculation why it's wrong as per the statute, but that cannot be the inflation, cost inflation.
No, why?
So,
That is the reason I
so that is one thing. If that is accepted arbitration, it's one thing. If that goes, if this damages, your argument is accepted arbitrator, even then, what principles arbitrator has to follow? That's
11.
yes.
11.
Yes, that's 11. Those provisions. So that's one thing. If this Banerjee's argument is accepted, then you have to show that it's in violation of 14A. It's violation of 14A.
That would be my second argument, my lord.
Yes.
Alternate argument.
So please make a calculation why, according to you, it's in violation of 14A. And Ms. Banerjee, you have to show
I will. do that.
what's the basis of your calculation as per this. You can give your basis of your calculation to Mr. Bordon. I'm not directing Mr. Bordon to give his calculation right now because that might prejudice. But since you have made a calculation, you have to give your basis of that calculation. Please give it to him so that he can also consider that whether it's in tune with 14A or not, and what's the infirmity.
The only difficulty, I will bow down to whatever Milan calls from your lordship. That is beyond the scope of the writ petition. His writ petition is
Ms. Banerjee, have considered that.
that's all.
I know.
Molding of beliefs at the final
Yes,
stage.
then I
So otherwise, the other thing would be I can give him the liberty to file a press
Right.
petition. So he will file another writ petition.
Right.
So he will file another writ petition in order to obviate
this has
that.
to be settled.
Yes. So
That is
only
what-
dispute is with regard to whether the adequacy of the compensation. If you say it cannot be rendered damageless, you cannot say no. Statute does not provide. Yes, he has to accept what I have determined. So if there is no statutory remedy available, he can approach the writ court.
Yes.
Now for that,
Then
What?
there will be an order where Milan I will win a matter before your lordship. And then he can come back. Otherwise, everything will get settled. He
No,
will buy something.
I mean, that's what step possible.
everything
That
is
is why. No, so if I show my calculation, your lordship, I will satisfy your lordship that I have done it in terms of
substantial justice.
this is my blood. I don't have too many orders where my name is there. Matter has been heard.
This is because he's so busy, she can't appear in before my
So
order.
when this matter came to me, Miller, I was very keen on arguing this matter because of Miller what fell from your lordship ultimately, and I thought that this is one of those matters in a land matter, Miller, where there will be a judgment where I
No, all these observations are privacy observations for both of you to do homework.
yes,
And only,
That-
so these are only the points which are given to you to
yes,
answer.
I will sit down and I'll do that.
After 3 queries from the bench, once you come prepared with the 3, on the 4th, on the next day, those 3 are not even there, the 4th one starts.
What-
One thing, Your Lordship, I was watching the proceedings.
CMC.
Because of the reasons I wanted to, because all through I was made aware, because I was the recording body. I had to pay the argument amount, but all through I was in the matter. Now, when he made this application after conclusion of the judgment of my lord, Mr. Orishta, now he preferred the application for appointment. Then I wanted to raise an objection by adding me as a party. Then court, my lord, since it's fair only for the appointment of the arbitrator, under that section, therefore, court, my lord, was not allowed by prayer.
Election bench affirmed it.
Right, took out an appeal. The court said that since it is a prayer for appointment of the arbitrator, if the court might not agree to his prayer, at that stage you need not appear. You need not consider. But if the court thinks of appointment of the arbitrator, of course you will have an opportunity of hearing in the matter.
Before the arbitrator.
But
No, not arbitrator, not arbitrator.
Bordon,
No, I appreciate this.
Mr. Bordon,
What would eventually fall is
What
that
I
you
was-
have to file a fresh claim and deal with the party.
Mr. Bordon, what I was thinking what Mr. Banerjee has said, then let it be decided. Other reliefs to do substantive justice without Mr. Ghosh's client, nothing can be done.
Yes, well,
So
I appreciate that.
now the division bench, you have approached the division, or Mr. Ghosh has approached the division bench, it has affirmed. So I cannot now
To the extent, my lord,
But the division bench order does not say that.
I
what the division
But the question is
No,
only there are two things. Mr. Bordon, with regard to the appointment, it's one thing. But if I have to go to the adequacy or sufficiency of the compensation amounts, that without hearing
No. The division bench of this, your lordship's court has held, a requiring body has no say in the matter.
No, that is with regard to the at the stage of appointment. But now the appointment
Quantum
to
of
be major
compensation.
law, appointment to be major
Quantum
law.
of compensation, the requiring body has no say.
In the factual scenario, then I have the right of audience.
This is the matter which
then, yes, all right, I will consider that. Ashun, hard mis- Supratim Bhattacharya, please keep a watch on the list, maybe in the first week of it. Please inform Mr. Kabir. Yes. Yes. All right.
Item number 49.
Which matter? Oh, that survey.
Well, Mr. Chatterjee tells me to concede matter, I cannot do it.
Because you have to face him outside the court also.
Absolutely. Your lordship is absolutely right. Your lordship knows. I have to survive at least. For few more, don't fear anything. For few more years. Yeah. Our no. My lord,
Don't say.
no. My lord, not pressing the application, my lord, with liberty to, my lord, approach the appropriate my lord.
আমি সেটা কি করে আক্রমণ করে দিলি
It's an interesting point, definitely. But my lord,
Yes,
instruction.
point was interesting.
Which is fine. It was interesting, but then what I friend wanted was probably not something that he would have thought.
Whatever it is.
So that's on the merit. It might be a different thing altogether, but
This survey act, its implications.
We
that
really,
itself, we
to be
don't-
very candid, my lord, we really don't get opportunity, my lord, to address, my lord, the court of such interest. We do it, my lord, but we are bound by reach.
no. Mr. Mitra, have you got the instruction?
Yes,
Uh,
I told them to, my lord, get things in right.
How can they do it without?
you have got that. Mr. Mitra, please. You may not be in difficulty, but your advocate on record and the instructing advocate.
May kindly keep it, my lord.
To be mentioned.
Tomorrow, not tomorrow, but Monday would be the monthly, my lord. Tuesday or Wednesday, any day convenient.
To be mentioned, I am keeping.
So we are not required to come. Mr. Secretary does not require.
You have to take instructions from your client whether your presence is necessary or not.
Mr. Secretary does not require.
Only for this, I can keep it under to be mentioned. So, if your instruction is otherwise, then I have to put it for hearing.
I don't think, my lord, the instruction, my lord, when came, my lord, I don't think it would change.
I think it will not change, but like something in writing.
Yes, Mr. Secretary, there, my lord, have been opposed laws. So kindly keep it, my lord, as to be.
Mr. Mitchell. Yes. Yes.
We have to take Lordship. Lordship is this matter. Lordship was used to call a report from the state authority. Lordship, after passing the order and by strength of this order, Lordship, I communicated the order to the concerned authority through WhatsApp. And Lordship, kindly see the reply.
What is the reply?
Due to SIR problem, they are engaged and due to that reason.
You want to place this on record? The court will be declared a holiday for that. This order was passed on 13th of January. Yes. No, 15th of January. In another matter, 13th. Yes. Report has been filed in this matter. Expressions to the report is also there.
After this report, another report was
Notice the let's go to
on 15.
by
15th January.
Mr. Dhot paid for time to file supplementary affidavit. I will not allow that. I will proceed with the report. On your prayer, you wanted to file a supplementary affidavit. Yes, please move this matter. Yes.
This is second litigation. Similar moved the litigation to the opposition, paying for compensation in the spiritual lands already acquired and used by the government.
This is the dot.
There was a direction upon us to come back with a report. My learned junior has contacted my client on several occasions. Then thereafter, we hardly got a reply. Then I requested him to WhatsApp the client so that written thing must be there. And thereafter, they replied by saying that we can't do anything because now they are busy with the SIR proceedings.
Which is more important, Mr. Dot?
Whatever has happened, I'm just narrating the facts.
Yes.
Thereafter, Manad,
Why supplementary
After
report
so
was
much-
called for?
because my learned friend has said that the land is involved about 29 decimals of land. And the price is, he is expecting that 58 lakhs. So we wanted to do this if my client is ready and willing. So I wanted to come back on this. This price has to be approved from the final authority that this amount is their agreeable. For that,
So that's subject to approval. The final authority may say, no, we are not agreeable.
yes,
That might be also.
that could be.
So
That's why my lord has
statute part 11, if direct purchase policy, let us not go with that. Let us proceed as per the statute. Because that's neither here nor there. Nothing concrete proposal has not yet come. So you will say something on epidemic, saying yes, subject to approval. Then after 6 months, you will come and say no, that has been rejected by such and such authority. So now we cannot pay.
after
I think-
affidavit, I don't think.
No, this is you are saying subject to approval. Subject to approval.
No, I haven't said that. Means the price my learned friend has shared with us, that has been communicated to them.
Yes.
So they said that they would go up and get the approval from the higher authority so that they can.
That amount.
Yes,
So I will record that you are agreeable to pay that amount, only approval.
subject to the approval. That's why.
That is what I am saying.
Yes.
That is what I am saying. After 6 months, you will be saying no.
Kindly give us a 2 weeks time so that we can file the affidavit.
2 weeks time may not be possible. I can keep it in the next week.
I wanted to finish this for the sake of the petitioner as well. That was my, otherwise, the judgments, all the judgments which is against me, I have relied on the judgments. I will not stand in the
File
way.
this report by 6th.
And Mama kindly mention it that this would be the last time.
Then I will record the grounds on which time has been paid.
Yes.
Mr. Dhol and its senior Yes.
Same concept.
Yes, who is appearing in 23? Yes. This is the same matter. So I'm keeping it on 6. None appears for the state. Yes, who is appearing for the state? Yes, report. What does the report say?
They are saying that they will only pay the utilized land. So far as the institution, I mean, when the order was passed, as per the delay proceeding, the entire land has been taken. I have been entitled for the entire land. Now they are saying that kindly come to paragraph 2 of the state report.
Paragraph 2, yes.
Paragraph 2, the special land acquisition officer, South 24 Pargana issued a copy of order sheet dated such and such to this office. This is office by Minister.
No, which, oh, special land, yes.
Yes, the order sheet of LA department is generally
No, what is the quantum of land which you are enjoying?
that has been kindly come to the rectification. That is the page number 56, madam. 53, and no, that is the order, madam. Kindly come to page number 58, madam.
Yes.
58 from the last, second last paragraph.
Yes.
Restriction number 1, Shoilen Halda. That is restriction of here also restriction number 1.
Yes.
Sanatan, he entitled for compensation of 0.0 acre of land with share 001. Thereafter, petitioner number 2, Shoilen
No, was this acquired?
Yes, my lord, that has been acquired. But now they are saying.
Where is the notification, acquisition notification?
Kindly come to page 57.
No, this is direct purchase policy.
Yes, my lord. This is the direct price. Kindly come to page number 57, my lord.
57, yes.
Verification of the record on order dated 26, order dated 22nd January 2025.
Yes.
On verification of record lying in the office, it reveals that RF plot being number such and such, such and such.
Which is your plot?
All these are my plots.
All these are your plots. Yes.
There are number of petitioners, number of plots are there. Kindly come to the end of that paragraph, madam.
Yes.
West Bengal on 6th February 1986 for construction of road from Jibon Mondor Ghat to Maheshwari Ghat. It appears that notice under section.
No, so there was no acquisition.
No, madam.
There was no acquisition. So initially 4-1 was there, it was maybe lapsed. So there has been no vesting now. So now you are entitled to only for the utilized land. Because other portions you are entitled, you are the owner. It's not that the state is owner with regard to the balance portion. If it is acquired, not utilized, yes, If it is acquired, you are entitled to the payment in respect of the entirety, even though a portion may remain unutilized. But here is the case where the land, the property did not vest in the state. It was 4(1)(a). Once issued, the notice lapsed. So now we are entitled to compensation with regard to the utilized land. What do you say?
Then I have to take instruction.
What instructors? Instructors will not agree. They will not agree. What is the law?
No, but there is another thing in the report. Now, there is a kindly come
Yes,
to paragraph
sorry.
number 5, my lord.
Yes.
Kindly, the paragraph number 4, my lord.
Yes.
This office, superintendent engineer and engineering survey and planning unit under.
Yes, this approval will be made.
They kindly come to paragraph number 5.
Yes.
What further administrative
This was a report on, I see, dated 5th of January 2020. Subsequent to that, my lord, another report that has been received by the Lord, I shall find the report today.
Yes. What is there in that report?
Lord, proposal has been put on, my lord, pursuant to your lordship's direction.
Yes.
It would be better if Mr. Banerjee had submitted the point, my lord.
Yes.
I filed the report today, my lord, but if your lordship has reviewed.
What does the report say?
You know that as per the previous measurements, the proposal for direct purchase has been put up by the concerned.
Yes.
Has no role related to further administration.
Yes. So this you say the superintendent engineer do not have any role.
He does not have any role in pursuant to any further. He only at
And
best
initiating the proposal.
yes, my lord. He can at best send the proposal to the
Yes.
concerned
So
officer.
proposal has been sent.
Yes, my lord.
So proposal has been sent now by the superintending engineer.
Annexure 2 of the report.
So what has been now done? This is pending before whom now?
For I suppose, Lord,
Let the district magistrate file a report as to what is the state.
Lord, in that regard, Lord, kindly please not put in Mr. Manager.
No, in fact, the proposal has been forwarded. Let the district magistrate file a report by to at what stage this is lying.
I beg to
Where is Mr. Banerjee?
Lord, yes, let the court for some personal difficulty today. That is the only reason that I'm in a fix today, my lord. Lord, I bow down to
You have initiated a proposal. So now the district magistrate is the head of that committee. Yes, Mr. Bandhavata, direct purchase policy, the district magistrate is the head of that committee.
District magistrate, sir.
Yes.
He is
So
the head of the
let him file a report as to what is the at what stage this proposal is lying. The Ashwin. The
Number 25.
Yes. Yes. Yes, what is the instruction?
On the last question, your lordship, regulated was fine, but it was not continuing the proper annexure. The lordship, I am praying for a seat adjournment so that I can file the annexure which was missing on the last one.
The learned advocate agrees for state rate for extension of time.
The supplementary.
The learned advocate agrees for the state submit
This matter. One,
yes.
2, 3, 4, and 6. There was a detention for filing affidavit. Affidavits are ready, we are filing.
The file.
No, not yet filed, but we are ready.
Oh, this is under 3 heads. Yes. Now what do you want?
Regarding 2 heads,
There is no problem.
there is no problem. 1 head.
That's the main head.
That's me.
Yes.
Then in this matter, I am also led by the learned senior standing counsel is he will be leading me in this matter.
Yes. What do you want?
For the petitioner, my lord, this is my reply. My lord, may I file the reply?
So this, you have not filed. You have said that you have not filed the opposition.
Opposition ready.
Oh, I thought that it will be affirming.
No.
My lord, kindly fix it in any name.
Affidavit in opposition and reply reaction. Next matter.
Number 27.
Yes.
This is my application. Mr. James filed his report. Now, Mr. Anand Banerjee was supposed to file the report on behalf of the PWD. And 3 occasions they were granted to him. And last year on 15th January, Lordship has looked at your Lordship's order dated 15th January.
Yes.
My lord, on previous occasion, your lordship was pleased to observe that the report that was filed, that was not sufficient, my lord. Lord,
What report? They have not filed any report.
he had filed a report, but that was not satisfactory.
So a written instruction has been given to him.
Yes,
Report was not filed.
yes.
He was not satisfied with the written instruction.
My lord, present occasion, my lord, he has yet to receive the report as per your lordship's direction, my lord. He had pursued the matter with the special secretary of the PWD, my lord, but she couldn't prepare it in time, my lord. Some more time may be granted to us, my lord.
On the prayer made on behalf of Mr. Banerjee, learned advocate.
Twenty-eight mirror, there was certain directions of one
Yes.
and may I respectfully invite your lordship mirror to the order dated 5th January 2020.
Yes.
Direction was under at 5th mirror 2 mirror
To complete the work of demarcation.
on this demarcation exercise to be done. Site plan to sketch map to be prepared.
That has been done.
That has been done in presence of other parties.
Now what has been found?
So that they wanted demarcation of the traffic lane lot.
So this is a portion was acquired.
46.246 is a letter which the ONGC had given to the that we need your assistance for identification and demarcation of
So
lot.
this is with regard to relinquishment.
De-requisition.
De-requisition. So now it has been done.
So demarcation done.
Yes. Have you given a copy of the report to them?
That was the first part of direction bureau we have complied with.
Yes.
And the second part of direction was
So have you served the copy of the report?
No, no.
to it?
yes, we have.
And the petitioner also?
The facility there was compliance with you have
Yes.
in compliance lordship direction bureau with compliance they will show us. The first compliance done and the second compliance direction bureau at page 3 of the order. Last paragraph. The accompanying authority is directed to communicate with the district that is with regard to approval of rental compensation.
Yes.
These are two directions. The first compliance is regard to this below. This demarcation part.
You have given copies to them.
Copy upon the other side.
Yes.
Which was given to the ONGC also.
ONGC has got that.
Yes, not being present at the time of demarcation.
But no, did you get a copy of the report?
Not this.
Mr. Galik, please give a copy of the
This is
report
what
to
I'm
them.
meaning. Now, second direction was that LA approval with regard to rental compensation. That I believe it has not gone to the ONGC, but that communication is given to me. I'm handing over a copy to the other side also.
Yes.
May I hand over to your lot close a copy of it is by LA, the special area.
Approval given.
No copies were given to any of the parties.
No, approval given. Approval given.
Yes, lordship kindly comes to page 6 of the report.
Page 6. Yes.
He says that in the LA manual it is written that up to 5 lakh limit, collector did not have to seek approval from any higher authority. So that is what he says as per para 34 manual, you can do it. This is what it says. And
This
next
is
bit-
so collector can himself do that.
Up to 5 lakh is the limit, LA manual says. So he just given information, not approval that you can do it. Why you are asking for approval? Next page, may I travel your lordship, next
7.
lordship.
Yes.
This is now the department of authority, ADMLA is giving from ADMLA to preparing body.
Yes.
That please you place the fund of total 23,000. That was the original rental compensation calculation for 2 plots of land.
Yes.
This is, I think, my learned friend for ONGC has not received it through their authority,
Yes.
but I have got it, so I am sharing a copy with you.
Yes. Please give a copy to the petitioner also.
This is last day Lordship was holding me right that why don't you share the documents with your junior? This is his conduct, Manish Biswas. He's a guitarist. Where does he go when Lordship does not? Half of the copies are with him now. I have only extra 2 copies. Now I'm giving it to petitioner. I shall share that.
Yes. Now, how soon you will pay this amount?
Yes, I'm giving this.
Yes. So now the approval part, and Mr. Galib, only one thing. The collector must know that as per the manual, up to 5 lakhs, no approval is necessary. Unnecessarily, this delay was caused.
Lordship, Willard,
In all matters, you are taking the plea, even for rupees payment of 100, approval to be taken. This is the circular as per the manual. Now, when you are directed that you have to give approval within a time, you are saying there is no necessity to take approval up to 5 lakhs. If that is so, why the collectors are sending it for approval?
Willard, here,
What is your answer to this?
So many words, Willard, is not said in the document which I have referred to your
Yes, approval is not
It
necessary.
only says that it is within the limits of your
Yes.
financial.
So, if it is within the limit, if it exceeds everywhere, in bank also, other things,
Yeah. Please subordinate is willing to get in touch with his
cannot be.
next highlight.
Mr. Galib,
Lord, you know this, Willard.
if it is
We know
within their
everything,
powers,
but we want to get in touch with some
or
hierarchy.
that, Mr. Galib, this bifurcation has been made only for that. In every matter, this approval should not be taken. Everywhere, limits have been given. In banks also, you will be finding for sanctioning loans. There are limits. Some limits, branch manager, thereafter zonal office, thereafter regional office, everywhere. So some power is vested with them.
Certainly.
So here also is a similar thing up to 5 lakhs, and they must be knowing, and stereotypes in all matters. It has been sent for approval. Why is it being done unnecessarily? This is being delayed.
We have no good answer to this. Why they have said
No, this was the first question you ought to have asked your client. If this was there, why did you delay? Why? What was the reason for sending it for approval? That's also your duty, Mr. Gali, to make them understand what is the provision.
Lord, this provision they themselves are putting, not
Yes.
that I am putting or we
No,
are
no, no,
putting.
no. They are saying.
They are,
So they must be aware of this.
so we Lord, and LA manual is with
So
very
this court can have the hope and trust that this collector will not send up to 5 lakhs for approval henceforth, because it has come within his knowledge.
no change of guard is there. Now the South 24 collector has changed.
No, he may go to now 24 for bonus, but it is within his knowledge, that person. He will not, during his tenure, will not do this.
Lordship may kindly will give me that able to deal with the issue.
Please
So
do that, because unnecessarily this should not be done.
Should not have been, should not have been. At least of 20. Earlier repetition was of 27. So, I had given words to your Lordship, that I get it done.
No, this has been, this you have done, but.
So, Millard, Lordship profile is this DLL or ADM.
What was the initial dispute? The dispute why the demarcation was sought for, because.
Was sought for us because, Millard, the entire land, Millard, was the subject matter of acquisition by 2 LA cases.
Yes.
Now, Millard, these writ petitioners are concerned with only one plot number, that is plot 206. ONGC is the requiring body. Acquisition Act was Act 2. Now, Millard, this ONGC requiring body in the year 1985 writes to the acquiring body.
I don't require that.
I don't. You go for the requisition of 1 LA case. All those plots belong to 1 LA case. This plot 246 is part of 2 LA cases alike. One is 1.02 acre,
which has been acquired.
which is subject matter of
They want derequisition.
They want the requisition.
Yes.
So for that, you have to demarcate only.
And the other is 79 acre.
That's not the subject matter.
That is also. That is also. So we are in one case here.
But here
So
the
far-
demarcation. Yes.
So far as 1.02 acre of plot number 46 is concerned, which they have already paid for derequisition. So for that.
Demarcation has been made.
Yes, yes, entire 79 acre.
So now they have to hand over that possession.
Two things have to be done there. So far as 1.02 acre is concerned, they need rental compensation followed by derequisition. We want that.
So let
So
us have the
79.
possession pass.
No, so the 79 acre is concerned, only rental compensation because they have not paid for it.
So when you will hand over possession and when the payment will be made.
My lord, so far as handing over possession is concerned, my lord,
Now you have got the demarcation report.
got the
So
demarcation, there is no
fix the
problem.
date here and now. I will direct your representative, Mr. Ghalib's representative and the petitioner's representative.
Kindly
When
fix the need.
you give us the date, because when I will be fixing a date, you will be saying FIR is there.
Lordship knows.
That is why I am asking you, give me a date.
3/4 the offices are vacant. We don't.
So give me a date. You give a suggested date. That is why I am leaving it to you. You suggest a date and time to all of you. Give us the time. On that date, possession will be handed over as per this sketch map.
Same as each. ADMLR report ही मिल गया. ADMLR each. इधर मिले ADMLR the sketch map and lordship I handed over the colored sketch map in
Yes, yes, color sketch. Have you given them the color sketch map?
not with color is only for meter road is running in between.
But Mr. Khalid, color sketch map is necessary.
I shall procure.
Because please give it to
I
them.
will procure and hand over to them. The
Because
colour.
this is the document on the basis of which they will be getting possession. So
Definitely.
color sketch map, they
I will
also
secure and I will procure and
please give it to them.
kindly lordship may kindly fix a date suffice so that we can also say it is a court date.
Please give a date, I will accept it. Please suggest a date. When?
After a fortnight at least.
Please fix a date.
Third week of February.
Give a date, not the week.
Lordship, one thing, 79 is also the derequisition we want back.
But
79 with
you don't want to take piecemeal possession.
I'm definitely 79 also.
You are getting a portion, you are saying no. The entire thing cannot be resolved in one day.
I got
Please take that amount, take this possession, then
it.
we'll proceed. Yes, where is that order which says that this portion will be derequisition? Where is that?
Page 90,
Milord,
92.
92.
the repetition.
Include all that.
Oh, that is impugned order.
So where they said that this demarcation is to be made,
Oh,
I think there was.
In the report, there is demarcation, you will know. The genesis of the entire case is lordship will have to go, Milord, to page 9 of the report. I handed over on the
Page 9 of the report.
No, that is the report dated 11th December 2020, which is not taken.
Yes, page 9.
This is the genesis, and this is what the requiring body is telling to the acquiring body. Derequisition of 8.86 acre of land. Now kindly see refer LA case 85.
Yes.
Now at the bottom below penalty kindly see the plots. Here
246 is
241
also
of
there.
the plots. So 85 is part is only 246 plot, 85 part is only 1.02.
Yes.
But 79 is part of another
Alright.
LA case that is below that is.
No, where is that? They said that this unless this demarcation is made.
Oh, that is the last day my learned friend for NGC had given one instruction lordship had taken on record
Yes,
and
yes.
dated
I think they are instruction.
20 December 2025. 20
Yes.
December 2025.
Cordial for identification, demarcation of plot
Lord.
number for providing the officer. I mean,
Lordship. Because of this, lordship was to direct that you go for demarcation exercise. 1.02 of plot 246 is part of ALAK's 85.
Yes.
Whereas 79 is definitely a plot 247, but it is part of ALAK's 9.
Yes, and where is that approval of this deliquestion? Where is that?
No, this said below that we'll have to seek the approval from the higher authority.
Page 16 probably subject.
So have you taken this approval of this handing over of position?
Page 10 below kindly see.
Only the demarcation stage has been
Where is your decision that you will hand over that position? Where is your decision?
Page 76 is 2000 prayer for deliquestion. Not page 76, this. I have already shown page
Repetition.
9. Page 9
Yes,
of
page 9 is the demarcator.
Page 10. Then kindly comes to page 10 below.
Yes,
Now ADM writes to Special Secretary Government,
Yes.
the Land Department.
yes.
Kindly see the last line below. Hence, the matter proceeding was initially in compliance with so and so. At
For
the time-
necessary approval of the requisition.
Yes, from
So-
your end, necessary approval, direct position.
So this approval has been given. Where is this approval given?
Miller, kindly see the next page, Lordship.
Yes.
In inviting a reference to the subject, that means it is referring to this letter, 23rd August 2024, reply is coming. In inviting a reference to the subject mentioned above, I am directed to state that the Honorable High Court ordered the special area to decide independently in the matter of deliberation, which was notified for acquisition following this.
So, no, Deputy Secretary writes to the Special Land Acquisition Officer that he is empowered to take decision. So now what did the Special Land Acquisition say?
Now, special LO goes through rental computation calculation.
No, requesting for handing over additional
Page 12.
to further process the deliquestion tender in compliance. Requesting
From
to give us-
ADMLA to, it has decided a letter will be issued to them in this regard to hand over possession. to
Where
the
is the
collector.
decision that this will be done?
It was the meeting
Page
of 28 November 2020.
District Magistrate.
Yes.
The representative of ONGC asserted that they are willing to surrender subject land as per letter of project manager. It was decided a letter will be issued to them in this regard to hand. So first they will have to hand over, then it has to come back to the acquiring body, then handing.
Yes.
So the acquiring body has to hand over to the acquiring body first.
You will hand over to them.
Then it will go back to them.
So it can be simultaneous also on the same day.
Paperwork.
So paperwork on the field, this demarcation will be done. You take
Demarcation already
possession and
done.
you hand over to them.
Demarcation already done.
Demarcation already done.
Deliquestion only with respect to
But
one.
where is that decision that this will be deliquestion? Where is that decision? I want to see that decision. Additionally, initiated the discussion, main issue calling for is to comply with the order, submit progress report. The representative asserted that they are willing to surrender. It was decided that the letter will be issued to them in this regard to hand over possession to the collector.
Here the ONGC
Free
will
from all encumbrances in favor of that. Sanction estimate. It is appeared that they wanted to act on the deliquestion proposal, then consider the
then 14, page 14 is the request.
Page 14 request made to the ONGC by the
page
ADM.
14 is the
Is
request
the
made to
request.
the
You hand over.
ADM is writing to the
to hand over.
Yes.
Yeah, hand over request.
Then after that,
After that, Lordships gets letter of this 12 December that we
that
have
to demarcate.
demarcate. So now again back to square one is this
The demarcation made, then they will hand over.
page 14.
So I'm recording your decision that you will hand over this to the collector. The special land acquisition officer will accept that on behalf of the collector. Mr. Khalid?
ADMLA, because page 14 kind of ADMLA is writing
Yes,
to requiring body that you hand over.
to hand over.
So ADMLA they will write a letter, yes, we are handing over.
And certificate also has to be. So I'm fixing. And how soon we will pay this amount?
That will immediately. I mean, this has reached us today, we will place it before the authority immediately. As soon as possible, we will disperse.
one of the issues raised in the petition is with regard to de-requisition. Yes, Mr. Galib is there, he has done that. Yes, next.
My lord, item number 20. And that matter, you will directed them to check the my calculation, and I have already
I need some more time, my lord, on 12.
My lord, I have also handed over the order. I have given copy of the
Yes,
judgment.
I have
And also the high court. Yes, I have
That those judgments.
yes, that judgment and degree I have handed over to Mr. Mahato.
Yes,
So he is acknowledging that, he is saying that he has done. On the prayer of Mr. Hard Mr. Already taken up. Four orders. I'm trying to adjust between motions and these four orders.
I know.
Because,
You will not give maximum time for
so I'm trying to accommodate some days motions are going to be given. Some upgraded matters also. Now hearing matters. Somebody is saying that.
Well, evolution order has been
Fast.
on not well, fixed on heart of February. Only 2 days
86. Who is appearing? Any one of you is appearing, Mr. Who is appearing for the state?
I have intimated because
To whom?
to
When you are mentioning, you must know who is appearing for the other side. You can inform them.
I will inform kindly give service only 2 days
Who is appearing for the state? Thirty-six, Mr. Bandyopadhyay, none of you. Sorry, no, 85, 85. 86.
We are not. We are in the active. I am just.
Who is the learned advocate? Supratim Dhar. Inform him 86. 86 টা কালকে